The vacation bench, we have only 3 working days for the division bench. So unless it's extremely urgent, please don't mention any matter. Thank you very much for.
That's only.
We mention corrections, those matters you can mention. Correction, please mention, yes. Application and order for 10 will add after the vacation. Please don't come.
As regards the mentioning made by my learned friend, my lordship, I had written it to my learned friend, my lord, to indicate as to what is the correction they are seeking. My lord, they are not informed.
Please give a copy to them immediately.
Your lordship, may I be permitted to mention on matter regarding.
So he's senior to. Yes, he started.
Yeah, may I be permitted to mention a matter which is not in your lordship list? My lord, this is matter.
What is the matter? Application or order?
Application.
No, as we said, after the vacation, please mention. We are not adding for these 3 days. Yes.
For inclusion under the heading of to be mentioned, your lordship.
What?
One order of stay was obtained by the
Yes.
learned division, honorable division bench, and the matter was sent back to the single bench. But it was found out in that bench that certain law points have not been framed. That's why the matter was sent back to the honorable division bench.
Why to be mentioned? Very well. I will put it on the list and then mention.
What's with your lordship? Will to direct urgent.
1 second. Sorry, please.
No, lordship may be permitted to mention item number 131. This is an appeal for child custody. There was a interim order for visitation right to the mother within a week, every Saturday for a week.
Yeah.
The only difficulty is that, your lordship, the child summer vacation has started. She expressed her desire to the father. Since the father is working in Bombay, she wants to go there. So, lordship, because we are almost at the verge of vacation, application won't serve the purpose. So, by way of mentioning upon due notice to the other side, we are giving an undertaking. With an undertaking, within 2 weeks, she will return.
Well, let us hear them also.
Lordship, obliged.
Yes.
Mentioning for inclusion, my lord.
Which lordship?
In the last order, my lord has directed the opposite party to maintain status quo as to
Yes.
the nature and character of the suit, but the other side has disobeyed the order of.
File a proper contempt application. We'll include the application. This is the application for what? You're mentioning an application.
Can, so we want it inclusion.
You have filed a can?
Yes.
Handover. It is yes.
Application in connection with hostel.
Other applications we are taking up after the vacation. Yes. Correct.
But one application for restoration.
No, we are not adding now. Yes.
I think there is second appeal for admission.
We are not taking now. We'll take after the vacation. We have 3 only working days.
Second application.
Next.
Lordship, may I have your lordship's leave to mention an application for stay, stay, and another lordship.
Come back after the vacation, ma'am.
Okay.
Call on the list.
My lord, I appear for the respondent in one of the appeals. There's minor corrections.
Is the
lordship.
correction?
Yes, lordship. My lord, in the first page, Mr. Shoptangshu Basu, senior advocate name has been recorded. My lord, he did not appear in the matter.
Yes.
And lordship, in several paragraphs, it's been referred that learned senior counsel, my lord, Mr. Oyan Banerjee, who led me, is not a designated senior. The word senior can be just struck out. And lordship, one more, just paragraph number 3 of the judgment, lordship.
Yes.
Line number 3 came into force with effect from April 1, 2024. It should be 2014, my lord.
Yes. Right. Learned counsel appealing for the you are for the land loser.
Yes, my lord. I'm
The
for
claimant.
Purvananda Basu.
Respondent item number 1
and
Claimant. Learned counsel for the claimant rightly contends that in paragraph number 3 of the judgment and order dated of the judgment dated May 8, 2025, it was recorded that the 2013 Act came into force from April 1, 2024, whereas the same should have been April 1, 2014. Let such order be deemed to stand incorporated. Let such correction be deemed to stand incorporated in the said judgment. Next para. Learned counsel further submits that Mr. Shoptangshu Basu, senior advocate, had not appeared in the matter, but his name had erroneously been incorporated in the cause title of the judgment. Let it be deemed that Mr. Basu did not appear on the said date.
I'm deeply obliged, my
lord.
And senior counsel is somewhat different from senior advocate, so we don't go into those technically. Senior advocate is under the Advocates Act a specific designation. You can be a senior counsel even if you are not a senior. Yes.
Deeply only.
My lord, there is minor connection, page 5, my lord,
Yes.
paragraph 18. Learned senior counsel of the respondent number 1 and 2.
But the appellants have said.
Yes, my lord, page 9 also,
Yes.
paragraph 32, second line. Defendant appellant, that should be, my lord, defendant respondent number 1.
Paragraph 32.
32. Defendant respondent number 1.
Not plaintiff.
Umapodo, my lord, paragraph 32. Doni Umapodo within bracket.
Oh, that. That should be defendant respondent number.
Respondent number 1. And another, my lord, page 13.
Wait, one by one will go.
Yes.
In the judgment dated May 14, 2025, comma, the following corrections should be deemed to be incorporated, colon diye, niche Roman 1. In first one was paragraph 19.
18, my lord.
In
First
paragraph
line.
18 of the same, comma, instead in the first line, comma, instead of the word double inverted appellants, comma, it should be read as respondent numbers 1 and 2.
1 and 2.
Respondent numbers 1 and 2. Push up in paragraph number 32 of the self-same judgment, comma, within parenthesis, comma, instead of defendant stroke appellant number 1, it should be recorded as defendant stroke respondent number 1. A third tab, yes.
Paragraph 46, my lord.
46.
Yes.
Yes.
7 line. DW1, that should be, my lord, PW1. 7th line. DW1, paragraph 46. Evidence of DW1, that should be, my lord, PW1.
Yes. In the in the 7th line of paragraph number 46, comma, instead of DW1, comma, the expression should read as double inverted PW1.
My lord, another thing, my lord, only, my lord, kindly send down the record to the trial court, my lord.
That is an automatic process.
With my cost, my lord, special messenger.
No, we shall not modify the whatever is there. Right. Yes.
For the appellant, my lord, paper is almost 90% ready.
1 minute, Mr. Budas, let us just check up.
Only binding and
1 minute, let us just check up. Sorry, yes. Paper book is not yet prepared.
No, already prepared. Only binding and page marking is left.
So then it's not prepared.
Not fully prepared.
Without binding.
Yes, that is the reason.
How can you file the paper?
Yes.
So what do you want?
Immediately after vacation, I will file it.
We had directed you to file within a limited time.
Yes.
On the prayer of learned counsel for the appellant. Appellant, comma, the time for filing paper books is extended till June 16, 2025. Yes.
Grateful to us.
So the office shall furnish a revised report as and when the service of notice of appeal is received.
Grateful.
Next. Yes, hello. Thank you. It transpires from the report of the Registrar Administration within bracket L and OM bracket closed dated April 11, 2025 that the corrections as the amendments stroke corrections stroke removal of defects as directed by the division bench order dated February 24, 2024 have not yet been carried out. Full stop. Next para. We find from the order of the division bench dated February 24, 2025 that it was recorded that the defects as pointed out by the assistant registrar within bracket SR section, comma, if not removed within 2 weeks from that date, comma, the appeal shall stand dismissed. Full stop, next para. Thus, comma, in view of non-compliance of the order, comma, there is no further scope for extension of the time for carrying out the rectifications. Full stop. In any event, comma, none appears for the appellants to make any such prayer for extension either. Full stop. Accordingly, FAT 448 of 2010 is dismissed for non-compliance of the court's order dated February 24, 2025 without any order as to costs. Full stop. Connected application, comma, if any pending, comma, stands dismissed accordingly as well. Next.
Interim order,
Interim order, if any, stands vacated. Yes. No Vakalatnama on behalf of respondent numbers 1 to 8. You are for the appellant?
Appellant, my lord.
Who appeared for the respondent?
Respondent, Mr. D.K. Odhikari.
Mr.
D.K. Odhikari. Dhanakrishna Odhikari.
Let us just check up the order, because it's recorded that in the order it was recorded someone was appearing.
D.K. Adhikari and
D.K. Odhikari. It transpires from the office report that although Mr. D.K. Odhikari along with Mr. Devdeep Odhikari had appeared on behalf of the plaintiff stroke respondent numbers 1 to 8 on December 9, 2024, when the matter was taken up by the court, and as such, comma, notice of service of notice of the appeal on the said respondents had been dispensed with, comma, no Vakalatnama has been filed as yet on behalf of the said respondents. Full stop. Accordingly, the learned advocates who appeared on the said occasion on behalf of the respondent numbers 1 to 8 are directed to file appropriate Vakalatnama within June 13, 2025. Full stop. In the event such Vakalatnama is filed, comma, the same shall be tagged with the main file. Full stop. In default, comma, the matter be placed for further placed in our list for passing further orders under the self-same heading on June 16, 2025. If they don't appear till then we'll direct you to put in postal requisites. And if you can, please give a notice to Mr. Odhikari or at least verbally inform him that we have passed this order. Otherwise, they won't be knowing. Thank you.
I'm for that.
Yes.
Lord, in terms of your lordship's direction dated 28th April 2025, Lord.
Yes.
I have sent all the copies by amending by incorporating the names of the pro forma respondent.
Right.
Almost 70 respondents, all of them have been served, Lord.
How many?
Served.
How many respondents?
70.
70?
70, including pro forma respondent, Lord. I have served them.
Partition suit?
Partition, full partition. Lord, I am paying liberty, Lord, to file this affidavit of service by tomorrow, Lord. These are the documents. Some have been returned back and some have been delivered.
The ones who which have returned,
yes,
say we will grant you time till tomorrow. You please indicate to us when you take up the matter tomorrow as to how many of them did not contest in the court. Not right now. Just make a list and tell us tomorrow. If you find that they did not appear, we shall dispense with further service and take up the matter. All right.
Actually, my lord, this matter is pending for long, Lord.
That is the reason we are passing these orders. Just give us a list tomorrow when you take up the matter as to how many of these unserved respondents did not contest in the court. Right?
Lord, that has been returned with a endorsement, my lord. Refused, not claimed, door closed.
Refused, not claimed, door closed will treat as good service.
Yes, that is tantamount to good service, my lord.
Yes. The ones which are not good service, like addressee left,
yes,
other things.
Deceased.
Out of them, deceased, you have to take out substitution application then.
Yes.
Deceased, you have to
I do not know their whereabouts, my lord. This is the problem, my lord.
It's appellant's duty. We cannot help you on that. We also don't know their whereabouts. That you have to do. Anyways,
one is
the part of the learned advocate for the appellant, the matter is adjourned for the day. Please come back tomorrow. Just indicate to us how many of the unserved respondents did not contest in the court below. And regarding the deceased also, whether he contested.
No, one learned advocate is entered his appearance, my lord, by filing Vakalatnama.
Point out tomorrow. Next. Make a chart of those who did not contest.
My lord, I am appearing on the appellants, my lord, on
Yes.
the request of learned advocate Mr. Malavika Dera.
Acha.
So this is an appeal, my lord, application for early disposal of the appeal. So she requested me to
There is
call
another
for the
application,
LC.
application for stay of execution case that has been disposed of, or what?
As per earlier allotted 16th October 2023.
Let us just check out. Interim order has expired. Execution case was stayed for a limited period. You are asking for expeditious hearing of the appeal without interim order.
And 1 of 23 disposed of. Order details.
You are directed to serve. What about the service? No. Learned counsel for the appellant fails to apprise us as to whether service of Can 1 of 2023 has been effected on the respondents. Full stop. কবে পর্যন্ত extension? Accordingly, let the matter stand adjourned till tomorrow, when learned counsel for the appellant shall inform the court as to the outcome of attempts to serve on the respondents.
Great.
Yes. There was a direction for filing affidavit of service. You have to file that also. Please inform Ms. Roy that
yes, ma'am.
She has to come prepared with the affidavit of service. Or you, whoever comes.
Yes, ma'am.
Yes.
Well, item number 9, I am for the appellant petitioner before your
Yes. Can 1 is pending?
Can 1 is pending. There is showing there some defects are there.
Some defects are there. You have not found the time to check up the defects of your own appeal.
No, because I have not filed because my predecessor interest has filed this one.
Your predecessor, you have an interest in the matter also.
Yes. Thereafter, the property was transferred to me by way of a gift. So at that time, what happened?
746 days delay. That is the only defect. Section 5 is also here. Any other information you require from us about your own appeal?
No.
Mr. Ganguly? No further information.
No further information.
Appeal is time barred. Let us dismiss the appeal for as time barred.
Yes. Give me some time so that I can hear out this section 5 application, because this application is not with us.
Why should we? If you don't have the application with you, you should not appear in the matter, Mr. Ganguly.
Well, I will talk with the learned advocate or the previous learned advocate and will collect the section 5
application. Would have talked with the learned advocate before the matter was mentioned before us.
Well, I was not aware that 765 days delay is there.
Learned counsel for the appellant seeks time to file an appropriate application for condonation of delay. Push up, let the matter go out of the list with the liberty to the parties to mention as and when such application is filed.
My lord, okay.
Out of this book.
My lord, I am appearing on behalf of the plaintiff, respondent number 1 to 4.
What is the appeal arising out of, Mr. Mukherjee?
It is out of a suit for partition. Wherein the
Final
preliminary decree, yes,
preliminary
decree I have challenged. My case is that the original owner was not the Vishnu Priya, because from Vishnu Priya the plaintiff is claiming through inheritance. I say in the deed of purchase of Vishnu Priya, it has been mentioned in the deed itself, it is out of the fund of his husband. And ultimately during lifetime of her husband,
yes,
her husband will transfer the property in favor of the defendant number 1. And thereafter, defendant number
You
one.
did not file any stay application?
Yes, your lordship has already passed an order, Lord.
Yes, what do you say, Mr. Sheth? We extend the injunction till disposal of the appeal, pass usual orders. You are appealing for how many respondents?
My lord, my submission is that
yes,
the original owner of owner of the property is Vishnu Priya Das.
Obviously, it's a disputed question. We are not going. Whether an arguable question has been raised, that is only to say. Arguable question definitely, since you are arguing, it's an arguable. They say that no, Vishnu Priya purchased with the funds of her husband. It was a benami, but not prohibited benami because wife. So it's an arguable question. We'll decide in the appeal. How many respondents are you appearing for?
I mean, I am for the respondent number 1 to 4.
So the plaintiff
1 to 4.
Very good.
This is the affidavit of service.
Mr. Mukherjee, you will have to serve notice of appeal on all.
I have been served with another notice. After your lordships passed the order for service of this application, Mr. Showman Dotto, his junior, wrote to me that he is also appearing for the opposite party, but did not mention which opposite party.
No, keep it with you. We
Yes,
cannot take
that's
note of
why,
that. Don't take the risk.
Yes,
Don't take the risk.
may I serve, apart from plaintiffs.
My lord, my submission is that as because this is the order in respect of preliminary degree, my lord, should maybe proceed till the
those orders have been passed.
Yes.
We have not passed.
Yes, yes.
We have already passed that order. We are not restraining the suit. Suit will proceed only final degree. We have passed that order, Mr.
Yes, sir.
So why are you repeating it? The present appeal arises out of a preliminary decree of partition. The defendant stroke appellant challenges the decree inter alia on the ground that the vendor, she was a vendor, their vendor.
No, they are claiming through inheritance from Milord Vishnu
that Vishnu Priya, that the predecessor in interest of the plaintiff's appellants, one Vishnu Priya, was not the owner of the property since she had purchased the property in Benami, with the funds of her husband, through whom the present appellant claims title to the property. Learned counsel for the plaintiff stroke respondents disputes such contentions. Since arguable questions have been raised in the appeal, we find that a sufficient prima facie case for injunction has been made out. Also, the balance of convenience and inconvenience and the irreparable injury ingredient are in favor of grant of injunction, since unless the property is maintained in statu quo till disposal of the appeal, the appellant may suffer irreparable injury and the appeal may be rendered infructuous. Accordingly, Can 1 of 2022 is disposed of, is allowed on contest, thereby restraining the plaintiff stroke respondent numbers 1 to 4 and stroke or their men and agents from transferring, alienating and or encumbering the suit property in favor of third parties and stroke or changing the nature and character of the suit property in any manner till disposal of the appeal. In view of the appearance of the plaintiff stroke respondent numbers 1 to 4 through their learned advocate, service of notice of appeal on the said respondents is dispensed with. Postal costs and other requisites shall be put in within a week from date by the appellant for service of notice of the appeal on the other respondents stroke pro forma respondents. The trial court record shall be called for by special messenger at the cost of the appellant, also to be deposited within a week. The trial court shall retain a skeletal record for the purpose of proceeding with the final degree proceedings. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Prathomei ekta diye diyo, affidavit of service filed in court today.
Only the final degree not to be passed, without the leave of the court, that your lordships granted on the last day.
Yes.
But since today's order is merging with that, that was for limited period. So your lordship is disposing of Can 1. So kindly record that also in this order.
No, that was passed in connection with this Can itself.
This Can itself, but till the disposal of this application, that order was.
It is made clear that the in view of appearance, it is made clear that the learned trial judge shall continue with the final degree proceedings, but shall not draw up any final degree without the prior leave of this court till disposal of the present appeal.
Gratefully, Lordship.
Restoration, Mr. Bhullo. When was it dismissed? This is within time?
Yes, within time. It was dismissed on, my lord, 6/11/2024.
Yes, it's only a few days after that. Well, there was no direction for service of copy of this application.
The order
We
for
noticed
till
from
manner-
we noticed from the order dated November 6, 2024 that the appeal along with the connected application were dismissed for default, which upon the said date, comma, none had appeared either for the appellant or for the respondents. First of as such, comma, applying the principle of Order 9 Rule 4 of the Code of Civil Procedure, comma, read with section 107 of the code, comma, we do not direct prior service of notice of the restoration application on the respondents. First up, the restoration application has been filed in time and we are satisfied with the sufficiency of the reasons for the absence of the appellant on the relevant date. First up, next para. Accordingly, can 2 of 2024 is allowed, comma, thereby recalling the order dated November 6, 2024, passed in SA 38 of 2023, comma, thereby restoring the said appeal along with the connected application bearing can 1 of 2023 to their original file and number. First up, it was at the order for turn stage.
Yes.
The appeal shall be listed under the head, listed for hearing under order for turn rule 11 of the Code of Civil Procedure in the monthly list of June 2025. Mr. Rokit, anybody appearing with you?
My lord, yes, my son is there.
Just give their names. It won't be recorded otherwise. Yes.
Item number 12, my lord, may I pray for short passover on behalf of learned advocate Mr. Susenjit Bonik appearing on behalf of
What
the
is he doing?
appellant.
What is he doing?
My lord, he is on the way, my
Passover.
Grateful, your lordship.
You're for the other side.
Man.
Just wait for. Yes.
My lord, I'm led by Mr. Kunalji.
My lord, I appear for the opposite party appellant, my lord.
Mr. Bhattacharya, this is appearing for the first time. Application?
Yes, my lord. Yes, I see, my lord, in the cause list there is defect showing, but my lord, we have filed can 2 for condonation of delay.
So let us just check up what is the defect. If there is any other defect. No, that is the only defect. So we'll direct you to serve copies and come back, both the applications.
Yes, and can 2, yes, has been filed, my lord. Was filed along with can 1.
Yes, yes. We'll direct you to serve copies of both.
As your lordship.
The appellant shall serve copies of can 1 of 2024 and can 2 of 2024 on the respondent, indicating that the applications shall be listed for hearing under the appropriate heading in the monthly list of June 2025, when an affidavit of service shall be filed by the appellant.
Grateful, my lord.
Thank
you. Grateful, your lordship.
Yes.
My lord, I am appealing.
My lord, I am for the
My lord, I am
petition.
paying for a short passover, my lord.
Every matter short passover, you are there.
Who is, my lord, may I know, my lord, for whom he is seeking
My
password?
lord, landed advocate Mr. Tanmay Basu, he is appearing in this matter in the
On what?
annex.
For whom? He is appearing in this matter for whom?
Respondent, or respondent.
One respondent only? Acha.
My lord, this is that matter, my lord, where I have doubted that whether the Vakalatnama has been filed or not. Now, my lord, by initially Mr. Dotto appeared on 10th March.
When did you file your Vakalatnama?
My lord, still now I don't have filed the Vakalatnama, my lord. I will file that.
No. Then you don't have a right of hearing.
My lord, please, I am paying for a short passover.
You don't have a right of hearing. Why should you pass over the matter? We are asking you, when did you file your Vakalatnama? We are passing it over for 5 matters, 2 matters. After 2 matters, we'll call this. If it does not come, you appear. Pass over for 2 matters. 2 matter বাদে এটা কল করবেন। এটা 14 তো 15-16 পরেই কল করবেন। None appears for the parties at the time of call. Let the matter stand adjourned for the day.
My application.
Not I appear for the husband.
Section 5 and stay application. I would remember in this matter, I had been able to obtain an ex parte order from my lords regarding stay of any further marriage. Mr. Chakraborty later on appeared and has filed an affidavit saying that on 15th December they have made. Now today we are on section 5. In the section 5, my only ground that was there, 270 days delay around.
Achha, we had recalled the order of stay.
Yes.
Because both parties, in paragraph 4 of that order, my lords have recorded that both parties have submitted before your lordships that before the order, marriage was conducted.
Not both parties, Mr.
That's
Chakraborty.
recorded. That's recorded in the order, my lord.
Mr. Chakraborty has submitted. We have.
What is the delay? What is the delay?
Delay of 269 days.
Reason?
Reason given because that the summons were not properly served and we did not know about the decree. When we came to know is when we filed a criminal matter, 498. When they came to take the bail, they for the first time showed that, see, there is a divorce decree. From that day, we applied for certified copy, we obtained it, and then it has been explained. We filed it as soon as possible. And the point that has been taken in opposition in that is that we have been, the respondent says that we have been properly served with the summons, hence we knew about the proceedings, and hence,
yes,
from the e-records, we should have checked out when the decree was passed. That is their only opposition. Well, kindly would take up the memo of the appeal first.
Have you filed any reply to that?
Yes, my lord. Reply is there.
One reply is there to the stay application.
And can one also is there, my lord?
Yes, reply is there. And opposition. Yes, you have found.
Yes. Yes. Kindly take up the memo of appeal where the, my lord, along with the certified copy, the summons has gone through. My lord, at the back.
The last page?
Almost the last page. The last and the before that. The summons and the declaration given behind the summons.
Yes.
My lord is there. I would kindly see the second line. It says that on 8th November 23 at about 4 p.m. on my inquiry and along with the help of local people, I came to the address of the defendant as mentioned in the summons. I called the defendant by name. A woman came out from the house and introduced herself as the defendant. Then I explained, they have gone on to say that she refused and I affixed the notice. My specific case that I've stated in the affidavit in reply is that I am a working lady. On that day, I specifically stated the name of the company and it is in Salt Lake. I was there in the office from 9 to 4. There is electronic records because there is a biometric records that I have signed in. And those could not have, were not annexed with the reply because we did not get it. At that point of time, she had subsequently changed the company. And I'm just handing over.
You cannot hand over any document without giving copies to them.
And I've stated that. I've stated that
you have short leave to produce at the time of hearing.
No, that is not there.
This is very serious. Because we have to call in question the authenticity of the court's bailiff, who is an officer of the court.
Yes.
So you have to put it on oath. File a supplementary affidavit, come back. Do you have access to your client?
Yes.
Or we can keep it on the reopening day, come back.
Reopening day, that would be better.
Come back with that. Not reopening, one day after that. Reopening will be the comment.
Lord, he will submit that. Only two things to just to draw your lordship's kind attention. Lord, we have prepared a list of dates. Would you lordship just look into it once?
When you take up...
Because why? On 7th of January 2024. Lord, this is very conveniently done. Why I say so? Just have a look at this for just 2 minutes bear for me only. Only. A copy. Copy দিচ্ছি ভাই তুই আমার থেকে দেখে নে
List of dates, actually, at least give them a copy.
Share it.
You submit from your memory.
I don't have that much of it. Just have a look at this.
Yes.
29th November 2018, marriage conducted. 30th November 2020, girl child born.
Where this relevant?
Not, my lord, may skip over that. Then kindly come to 7th January. 18th May 2023, divorce suit filed. 7th January, wife took back all gold ornament. That's not disclosed in the application. We have annexed that in our affidavit.
Why is that relevant?
Lord, because the parties were living separately.
That is a ground in the suit.
Divorce suit, she knew about the divorce suit.
How could she know? She came and took ornaments. Does not mean she knew about
by signing the document that we are living separately.
That does not mean that she knew about the suit. There was a rift between you. She came back and took back her ornament.
I bow down to your
That has nothing to do
kindly
with
then kindly proceed. 3rd June suit decreed ex parte.
Yes.
15th December I remarried. 22nd December I have annexed air tickets that we had, the family, entire family went to vacation. Air ticket, hotel booking, we have annexed in our affidavit.
You went to Rajasthan because Rajasthan, the High Court has a judgment on this. Section 5 should be rejected. If
I am carrying your lordship's judgment and our honorable.
Not as a matter of course, Mr. Chakraborty. Not that in every matter this only on this ground it will be rejected.
Now what happens thereafter?
That may be one of the considerations before the.
Now what happened thereafter on 26 December after I conducted remarriage, she filed a 156(3). Now what is the cause of action? Saying that she left the house in August 2023. So 1 year, 4 months after she left the house, she went there and filed a 156(3), just after the second marriage. Now she says that when I went there to obtain bail, she got to know. That's a date of knowledge. I am carrying the judgment of the order of the court. Kindly have a look at it. If she was there before the court, she would be knowing that's a date of knowledge. Kindly have a look at it, the order. 9th January order. Record is put up today. Lord, kindly appreciate, Lord. 35(3) notice was issued. The record was put up. So there was no option, no opportunity for her to know unless she put a guard on there or she was waiting for the entire month. 3rd January FIR registered. 9th January record is put up. Accused so and so present surrender before the court. They are taken into custody, remanded to JC. One petition praying for bail filed. Nothing transpires from the submissions of the learned advocate for the accused or from the record of the case under section so and so is pending or has been rejected so and so. Hard submission of the defense counsel. That's my lawyer. APP raises no objection. Hard both side, peruse all materials on record, which appears on the case record, accused person voluntarily surrender so and so. Even the case diary was not called for. From the record was taken from the GR. How was she present in court? How did she know on 9th of January, I'll be moving a bail and I'll getting the bail? Her case is date of knowledge is 9th of January. She says she was present in court. That's a pleading that non 9th.
Hard submission of learned defense counsel.
That's me.
Defense counsel.
And the APP raises no objection because it's a 498 case, 35(3) notice issued. I went there and surrendered magistrate tribal offense.
Her presence was not recorded anywhere.
She was not even present. How would she know, my lord? How would she know? I could understand the CD was called for, that the investigating officer called her. This is a blatant lie.
Well, this fact
Very
I will
conveniently
inquire from
created.
the learned trial
So you have
court.
You have
Yes,
to, that's
I-
why I'm bringing it to notice.
Yes.
Learned counsel for the petitioner seeks to produce further documents. Post of leave is granted to the petitioner wife to file a supplementary affidavit to her application for condonation of delay with an advance copy to the learned advocate for the respondent. Post of learned counsel for the respondent hands over a copy of a connected criminal case, in respect of which the wife alleges to have derived knowledge of the ex parte decree and submits that the first order in the said proceeding indicates that the wife was not present, and as such, the premise of the date of knowledge as alleged is incorrect. First up, be that as it may, in view of the adjournment sought by the petitioner for filing a supplementary affidavit, let the matter stand adjourned till June 10, 2025.
Now it is only a ego.
My
3
lord, may I
lives
just
will be
make-
lost.
May I just make
You
one
affirm that affidavit immediately and give them a copy before the vacation.
before the vacation it will be. Well, may I just make one prayer? But in our opposition to Can 2, they have state that on 15th December he has conducted remarriage. We dispute that fact. My lord, on that, my lord,
You already disposed of the stay
Yes,
application recalled or other.
my lord, may I just make this. My lord, we say that he has not married. My lord, kindly passes one line order saying that he will not register the marriage or conduct any
Why?
further social marriage.
What will you achieve?
That
by
will
it?
jeopardize the third
Yes.
party. Definitely not.
Very
And
well.
on 10th of March, the order, it has been recorded that both parties submitted that it was not informed to court and the marriage was conducted before the order.
Next matter. Follow me. 10th থাকে। Password হ্যাঁ যেটা দু ম্যাটারের পাসওয়ার্ড আছে হ্যাঁ আগে আরেকটা পাসওয়ার্ড আছে
My lord, I am appearing on behalf of the respondent, my lord.
What is
Mr.
the filing number of your Vakalatnama?
My lord, just file of Vakalatnama is with me, my lord. I just filing within course of the day, my lord.
You had appeared on the last occasion, you had submitted that you are not.
My lord, on 10th March, my lord, when this matter was taken up,
Yes.
Mr. Dokto appeared and submits that he is entered appearance on behalf of the respondent. As such, my lord, on that date, your lordship, my lord, dispensing to service of
Yes.
notice of appeal. And my lord, on the next day when this matter was taken up on 21st, my lord, I indicated that there is a
This is
chance
on
that,
indication we inquired and found out.
yes, and then
What
no
is your full,
Vakalatnama-
who will file the Vakalatnama? In what name?
In Tanmoy Basu, my lord.
It will be, will not take up the matter today. We'll keep it tomorrow, file it and give the entry
Yes.
number tomorrow.
Yes.
On a previous occasion, Mr. Dotto had appeared on behalf of the respondent, on which premise we had dispensed with service of notice on the respondent. However, on being pointed out by learned senior counsel appearing for the appellant, it was discovered that no Vakalatnama had been filed on behalf of the respondent. Next para, even today, it is submitted that Mr. Tanmoy Basu shall file Vakalatnama on behalf of the respondent. Let the matter stand adjourned till tomorrow. The Vakalatnama on behalf of the respondent shall be filed by today, and the learned advocate for the respondent shall apprise the court of the particulars of such filing when the matter is next called on for hearing. Affidavit of service filed today be kept on. Tanmoy Basu having instruction to appear for the respondent বলে ওদের নামটা লিখতে হবে।
My lord, I am for the
এটা আরেকটা পাসওয়ার্ড দিতে।
My lord, I am for the respondent number 1, my lord.
My lord, on in terms of your lordship last order,
এরপরে আগে অন্য পাসওয়ার্ড ম্যাটারটা ডাকবেন। Yes, Mr. Hussain.
my lord, in terms of
Sorry, you are for respondent number?
I'm respondent number 1.
1.
My
Lord, in terms of your lordship's order dated, my lord, 5th May 2025.
Come to the microphone, Mr. Hussain. Come to the microphone.
Yes, my lord. In terms of your lordship's order dated 5th May 2025, my lord,
Yes.
there was a direction to serve upon the respondents, my lord. There are 2 respondents, and my lord, there was a direction and
What about service on the other?
Yes, all have been served. The other respondent, my lord, is a developer, and the
Good
respondent.
service affected.
Yes.
My lord, I'm
Service
respondent number 1. There are
Yes.
13 points is to be taken on. Well, in this petition, they have suppressed certain facts. That is there is a long-term relationship between the respondent number 1 with the petitioner's father. And out of that affection, love and affection, she has already donated her kidney. What has been suppressed in this
Lord,
petition?
Yeah, I just
Donated her kidney.
parties are,
And,
there is a talk of settlement going on, my lord.
also, yes, let me clear first, my lord. There is a talk of settlement is going on, but they have suppressed the fact that she has donated her kidney out of the love and affection voluntarily and
Talk of settlement cannot go hand in hand
yes,
with
at the
arguments.
same time, the
Either you argue the matter, we'll hear you on merits, or you will have a
there
talk
is
of
talk of settlement is going on.
And we have
How long
accepted
shall we
the
wait
offer.
for that talk of
We
settlement?
have accepted the offer. We have accepted the offer.
How long shall we wait for the talk of settlement? Both of you tell us.
Yes, my lord, 1 month post vacation, my lord. We have substantially accepted the offer, but it has to
Why
be
1 month after you are
Lord,
enjoying
it has to be put on
Then we'll
record.
limit the interim order, Mr.
My lord, there are several.
We'll limit the interim order till 1 month after the vacation and put it before.
Yes, my lord. My lord, may that.
There is another
My lord, my lord,
lower court also we have
Keep
got.
it with you.
my lord, why I'm seeking time, my lord. Why it will take time? Because apart this suit, there are other proceedings also pending.
Learned counsel for the appellant submits, but we will direct it to appearance. Learned counsel for the parties submit that there is a talk of settlement going on. Accordingly, on the prayer of parties, let the matter stand adjourned till give us a date. 1 month, he says. Today we are on 19th. So we'll keep it on 23rd of June.
Yes,
Till June 23, 2025, when it will be listed under the same heading. Affidavit of service filed to be kept on record.
Grateful.
learned counsel appearing for the party submit bolam na? Learned counsel appearing for the appellant and the respondent number 1.
Yes. Grateful.
Thank you. Yes, Mr. Boli.
Last occasion, your lordship directed after admitting the appeal.
Mr. Banerjee, you are for the other side.
Yes, my lord.
Application is there.
Defendant.
1 to 3.
Yes.
To Milord the
Yes, Mr. Boli.
defendant to file Milord affidavit in opposition in injunction application. They did not file it. However,
My lord, this appeal subject to your lordship's kind sanction, my lord. If my lord kindly grants me 1 minute time, my lord, this appeal can be disposed of.
What is the appeal
My
again?
lord, appeal,
this appeal, Milord, arising out of
Let us hear them on
Yes,
the
yes.
this appeal, Milord,
We'll give you that 1 minute after him.
arising out of the review petition. Your lordship kindly remember the review application was, Milord, allowed only on the ground that to satisfy the claim of the appellant, that is the revisionist. Now, initially the application under Order 41, Rule 27 was, Milord, considered and rejected by the learned appeal court below. Now, again, Milord, in review petition, they have agitated that application to be heard. And that has been considered and allowed the review application. Your lordship kindly see the impugned order.
No, review of what order?
Review of the appeal court order. Appeal court judgment and Milord order.
The full-fledged judgment.
Yes. The preliminary decree was passed in
That judgment, preliminary degree passed?
Yes.
And Order 41 Rule 27 was?
Preliminary decree was passed, Milord. They preferred an appeal against that preliminary decree. In appeal, Milord, they filed an application under Order 41 Rule 27, but only to Milord, to prove the fakeness of Exhibit 6.
Right.
That application has been considered and rejected by the learned appeal court below. Thereafter, they preferred the review application. That has been allowed on the ground of that to satisfy the claim of the Milord, the respondent.
Let us see the impugned order.
Yes, kindly see.
Title appeal was dismissed also.
Title appeal dismissed. That has been rejected. That Order 41/27, they have preferred the appeal. In appeal, they have filed an application.
Appeal was also dismissed.
Appeal dismissed.
His appeal was dismissed.
Dismissed.
And Order 41/27 independently dismissed.
Rejected.
Also. By the same.
Yes. By the same judgment and decree. Thereafter, the review application was filed. In the review application, my lord, the learned trial judge, the appeal court below has considered that this application was considered and rejected in the title appeal proceeding, but allowed the review application only on the ground to satisfy the claim of the Lord, the revisionist.
No, it was reviewed on the utter cry of justice.
Yes, yes.
What is the appeal court's judgment?
Your lordship kindly sees the application.
Only that portion has been reviewed. 41/27 has been.
41/27, Lord, that is the ground. That is the ground. Your lordship kindly sees the.
So entire title appeal has been restored.
Yes.
Title appeal was dismissed on merits.
Yes. Your lordship kindly see page 30 in my application for stay. Page 30, Annexure D. That is the judgment of the title appeal. 29th of April 2015. Your lordship kindly sees the ordering, the portion, the main portion, the page 36. In the result, your lordship.
Yes.
Page 36 below the adjournment.
Yes.
Page 36, Milord, the second paragraph, Milord. In the result, I do not find any merit in the instant petition of the appellants praying for admitting into evidence of the certified copy of the deed number 4184 with respect to the plot number such and such as filed by the learned advocate of the appellants in support of their appeal case. The defendants cannot at all be allowed to fill up the lacuna of their case at this stage through instant petition and certified copy of the deed number 4184 with respect to suit number such and such. The other deed which the appellants are trying to bring into evidence is not connected with the suit properties, and thus I do not find any merit in the instant petition under Order 41, Rule 27 Civil Procedure Code, and accordingly same stands rejected. and my lord, thereby my lord rejected the appeal itself. Your lordship kindly sees the
Yes, there's
yes.
contrast to these made out of case. The cases were considered and dismissed.
Yes.
No, the review was done only on the order for 27 ground.
Only your lordship kindly sees, my lord. The first page of the impugned order dated 18th of November 2020, the last portion, the bottom portion of paragraph, my lord, bottom paragraph.
Yes.
From the aforesaid application under Order 47, Rule 1 of the CP Code, it reveals that the petitioner appellants, namely Alauddin Mondol and 15 others, submitted certified copies of 2 deeds of sale of the same number and the date of the Exhibit 6 showing transaction between different persons relating to different lands not connected with the suit land. Point number 4 in paragraph 2 of the said petition. In paragraph 6 of the petition, it is stated that this court, without disposing of the said application seeking adjudication about fakeness of Exhibit 6, dismissed the appeal. In paragraph 7 and 8 of the said petition, it emphasized that the appellant petitioner sufficiently stated that Exhibit 6, by virtue of which the learned court below decided title in favor of the plaintiff respondents was fake, and thus the share was subject of inquiry of the learned appeal court, and its attention was drawn accordingly, but the same was ignored by this court, and the said application was left unadjudicated. This was the ground taken by them in this application. Now your lordship,
unadjudicated means which application? Order for
27. Your lordship kindly sees this. Thereafter, the learned trial judge, your lordship sees, my lord, thereafter the amendments made, my lord, the
yes, we have seen, call out the truth and all.
Yes.
Yes, Mr. Monik, you have read it. Let us hear, Mr. Vani. Yes, Mr.
There only one thing. I was the defendant. My lord, after the pronouncement of the preliminary decree, I got hold of certain documents of the deed. Now, I took out an application under Order 41, Rule 27 in my appeal. My lord, at that point of time, it was turned down. Now, my lord, I took out this review petition, and my lord, this review petition has been allowed. Now, my lord, if my lord allows their appeal, my lord, then very well, I have a right of second appeal, and in my second appeal, I can very well agitate this question whether the learned court was improper in allowing declining.
Subject to Section 5.
Yes. Order 41, Rule 27, whether it...
We are concerned only with the review, and we'll
Yes.
say that this is beyond the scope of Order 47.
Yes.
That won't affect you either way. We are not taking away your right of second.
That's fine.
But we won't create a right of second appeal by virtue of our order. If you have a right, you have a right. If you don't have a right, you don't have a right. What you are asking for, we will not do.
But that we will do.
That you do. You do. On consent of parties, the appeal along with the application are taken up for hearing. Yes, you are right in a sense, Mr. Banerjee. This is a logical approach, because if you have to take out a second appeal, after 10 years, we'll dismiss this appeal on the same ground.
I said, my lord, it can.
That's absolutely rational. We appreciate that, but we cannot record that appreciation here because your fate of your second appeal will be prejudiced. On consent of parties, the appeal is taken up for hearing along with the pending applications. Full stop. Next para. The present challenge has been preferred against, both of you take it here, preferred against an order whereby an application for review under Order 47, Rule 1 of the Code of Civil Procedure filed by the respondent was allowed by the learned appellate judge. Full stop. Next para, learned counsel appearing for the appellant points out that the review application arises in connection of a judgment passed in a first appeal from a preliminary decree of partition. Full stop. In connection with the said appeal, an application for production of additional evidence under Order 41, Rule 27 of the Code of Civil Procedure had been filed by the respondents, which was decided on merits and rejected by the appellate court simultaneously with the dismissal of the appeal on merits. Full stop. However, the learned judge, in the impugned order, allowed the review application on the only premise that the petition under Order 41, Rule 27 of the Code of Civil Procedure was disposed of within double inverted with odi -alterem -partem double inverted close full stop. It was further recorded that in order to cull out the truth, documented evidence was required, and on such vague grounds, the review application was allowed, thereby restoring not only the application under Order 41, Rule 27, but also the appeal itself, without addressing the merits of the review application on the appellate court's judgment on merits as well. Puts up next para. Learned counsel appearing for the respondent controverts such submissions. Puts up, however, comma, on a bare perusal of the impugned order, comma, we find that the learned appellate judge acted palpably dehorsed the law in allowing the review application. Push up next para. In the judgment under review, comma, the appellate court had dealt with the application of the present respondents under Order 41 Rule 27 of the Code of Civil Procedure on merits, comma, thereby coming to the finding that the defendants stroke present respondents cannot at all be allowed to fill up the lacuna of their case at the appellate stage through the said application, and certified copy of a deed sought to be produced. Pushed up. It was further recorded that the other deed which the appellants were trying to, appellants therein, within bracket present respondents, bracket closed, were trying to bring into evidence were not connected with the suit properties. Pushed up next para, thus, comma, the dismissal of the application under Order 41 Rule 27 of the Code was squarely on merits. Pushed up. Contrary thereto, comma, it was argued by the present respondents in connection with the review application that the said application for production of additional evidence was left unadjudicated. Pushed up. Although quoting the relevant portion of the initial order, initial judgment of the appellate court, comma, the review court merely came to certain general and vague findings, such as evasion of process is not wanted, and that evidence is required to call out the truth with regard to any documented evidence. Push up. The review court further observed that outside the periphery as coded CODED in the legal avenue, comma, the utter cry of justice demands to dive into the disputed matter in question and resolve the same by additional evidence or else in accordance with law. Push up. Next para. We find that the said observations of the observations in the impugned order are not only unintelligible but a fruitless exercise in jugglery with language, comma, without having any substance whatsoever. Full stop. The learned first appellate court, comma, while allowing the review application, comma, did not even care to advert to the parameters of review under Order 47 Rule 1 of the Code of Civil Procedure. Full stop. In view of the learned first appellate judge, comma, at the first instance, comma, having fully considered at length and on merits the application for production of additional evidence, comma, the review court erred in law in allowing such application and reviving the application under Order 41 Rule 27. Which of next para, the matter, a matter of serious concern is that apart from dismissing the application for production of additional evidence, comma, in its initial judgment, comma, the first appellate court had decided the appeal itself on merits. Full stop. The review court, comma, surprisingly, comma, did not touch such adjudication on merits and, comma, as a matter of course and mechanically, comma, along with the application under Order 41 Rule 27, comma, also revived the judgment passed in the first appeal on merits. Full stop. Such an approach is not only careless but should be avoided by judicial officers. Full stop. Next para. In any event, comma, without going further into the irregularities in the impugned order, comma, we find that the parameters of review having not been satisfied at all, comma, the impugned order is contrary to law and as well as the applicable legal yardsticks. Full stop. In such view of the matter, comma, FMA 702 of 2023 is allowed, comma, thereby setting aside the impugned order being order number 41 dated November 18, 2020, passed by the learned additional district judge, 4th court at Berhampur, District Murshidabad in miscellaneous within bracket review case number 31 of 2015. Full stop. Consequentially, the applications pending in connection with the present appeal are also disposed of. What are the applications pending?
Only one application.
Can one.
Other application has been disposed of.
This is can one.
One.
That is can 1 of 2021 stands disposed of. Full stop. There will be no order as to cost. Full stop. This much.
Yes.
Thank you, Mr. Banerjee, for the fairness.
Unnecessarily, it will continue, my lord.
5 years after that, your client will have the same fate, and then you'll have to go back. Yes.
We have a Mr. Kobi Maji not to paying for not.
Why? Where is he?
Temporarily indisposed of money.
Temporarily in this. Temporarily, what happened to him?
Let's see.
Are you enjoying it? Oh, this is a Section 5 application. We'll keep it after the vacation. On the prayer of learned counsel for the appellant, let the matter stand adjourned and be listed next in the monthly list of June 2025. Please give both of your names. Yes. You also give your name. Not Mr. Maji's name. Yes, sir. Yes, Mr. Chatterjee.
Well, this is the judgment and order dated 22nd of January 2025 is under challenge. My lord, this is an order passed under the Guardians and Wards Act, the judgment. My lord, I found
you are the mother or the father?
I'm for the father. I was the
age of the child, Mr. Chatterjee.
My lord, the child's age is presently
yes.
So it should be
male or female?
14 years, male child.
14 years?
14
boy,
years,
yes.
I got 14 years, my lord, I will subject to it.
So you filed an application for guardianship and custody?
And finally it has been decided, my lord. Finally,
no visitation rights
in favor of the mother. 13 years old, my lord, I stand corrected.
No visitation right given to you?
Nothing. Lordship, kindly come to this. It's kindly come to paragraph number 22 onwards of my, this is the judgment, internal page 7.
Yes.
Of the judgment, paragraph 22. Admittedly, the petitioner has got second marriage, and out of the said second marriage, he has 3 children who are all female babies. And as his second wife could not give birth to male baby, he might have taken the calculated attempt to take the said child back to his house. In this perspective, the child witness is telling the truth that he never spent a single day with his father since his birth. And said child witness also found firm when the court put the following questions. Your father is a rich man and he can provide you better amenities in life. Would you go to your father's house? Answer, I do not want to go to my father because he never came to see me and my mother, and I had not seen his face since my birth. My lord, kindly come to paragraph, because the entire sole, the judgment has been passed upon the sole consideration that it is passed in for the sake of the welfare, paramount welfare of the child. My lord, the 24 records, with regard to the amount of income or source of income of the OP, it is pertinent to mention that she works as maid, whereas the petitioner has stated before the court that he is a day laborer. Therefore, none of the parties has definite fixed income. For both of them are more or less on same footing, and so argument of the petitioner that he has sufficient means of income that OP is not convincing. My lord, there is no definite finding on the how the welfare would be taken care of. My lord, I am a daily laborer, admittedly, and even the court did not arrive to the finding that my wife, who is presently been granted with the custody, whether she has that amenities. There is no definite finding on this. Para 27, my lord, this is another part where I found there is an error. With regard to this issue, the pertinent to mention that under the Guardians and Wards Act, this court has no authority to appoint a guardian of the minor whose father is alive. It is also fact that under Mohammedan law, a father is entitled to get the custody of the child if the child has completed.
Both of you belong to the Muslim community?
Yes, my lord. That is the another point on the basis of which this was moved that after 7 years that I becomes the. Now this issue has been subject to correction, my lord. It has been dealt in a different manner. It is also fact that under Mohammedan law, a father is entitled to get the custody of his child if the child has completed the age of 7 years and the father is found fit person to receive the custody of the child. Here in this case, admittedly the petitioner has married second time, and out of the second marriage 3 children are born. On the other hand, the OP has not remarried, and therefore she is in a better position than the petitioner and mother could provide better care, protection and said child, right? So this finding also has been arrived on the basis of very feeble logic, lordship, what I found.
We
And
find it a strong logic, Mr. Chatterjee.
my lord,
Your second marriage, we have no objection with the second marriage. You have 3 children out of that marriage.
yes, my
You have to, you are a day labor. Now you have to take care of, if this child goes to you, you will have 4 children who for whom you have to take care. It will be difficult not only financially, whatever may be your income as a day labor, the maximum that you can earn, it will be a burden on you also and the family also.
But
and compared to that, a comparison, if a comparison is made, she also works as a domestic help in houses, but she has only this child. She has not remarried, so the child is in better hands.
Lordship,
You don't find any difficulty.
so
with
there
this?
is no
And Mohammedan marriage, this Hindu marriage, Mohammedan marriage, the Hindu law, Mohammedan law, whatever may be the law of custody, paramount consideration
interest
you
Oh.
of the child. Lordship,
and 14-year-old child has intelligent preference, Mr. Chatterjee. His preference was taken. What is the difficulty?
even no
We can
petition
just look
rights has been
into
given.
visitation rights scenario, and we'll admit the ground only on that limited point.
Kindly,
Only on visitation will make it clear in our order.
at the same time, lordship, that though it has to be established after that from the depositions, lordship. So far, my statement regarding the day laborer is concerned, lordship, I can show my earnings also. Lordship, kindly consider that aspect also, and kindly grant me in an opportunity to perform my duties towards the child. My lord, kindly ensure that.
No,
If your lordship
we'll
is
directly
inclined
serve
to
copy
admit
of-
it, yes.
We'll admit the appeal. We'll admit the appeal. We'll say that on the limited ground of visitation rights, you're entitled.
Well, kindly.
We'll make it clear in our admission order, and Mr. Chatterjee will direct you to serve copies of the memo and the application on the respondent.
My lord.
Will not pass any visitation order right now without hearing the other side. We can give a short date. We can keep it on 1 week after the reopening.
My lord, kindly.
You can serve in the meantime. Learned counsel appearing for the appellant father submits. Learned counsel for the appellant father submits that the learned trial judge erred in law in applying erroneous legal yardsticks in passing the impugned order, whereby the appellant's application for guardianship and custody of his minor son of 13 years was rejected. Push up next para. Learned counsel points out that one of the considerations of the learned trial judge was that the appellant has remarried and has 3 childs of the said marriage, comma, which according to him, according to counsel, comma, is an irrelevant parameter. Push up next para. Moreover, comma, the income and solvency of the parties, comma, who are respectively a day labor and a domestic help, comma, were not considered while granting custody. Push up, it is submitted that it was also not considered by the learned trial judge as to whether the respondent mother has the wherewithal of nurturing and taking care of the child as opposed to the appellant father. Push up, learned counsel takes the court through the relevant portions of the impugned order judgment, where the learned trial judge, comma, although referring to the provisions in Mohammedan law, comma, by which the parties are governed, comma, regarding the custody of the child being with the father up to a certain age, comma, did not properly adjudicate on the same. Push up, next para. We find from the impugned judgment that the learned trial judge adverted to all the relevant considerations and primarily passed the judgment on the paramount consideration of welfare of the child. Full stop. Also, comma, since the child is of 13 years age and is sufficiently capable of having an intelligent preference, comma, we find that the learned trial judge rightly interviewed the child and took his opinion as well. full stop, that apart, comma, in respect of custody, comma, the learned trial judge balanced the social positions of both the parties, comma, being that the appellant father has a second marriage, comma, from which he has 3 children, and also the fact that the father is a day labor, while on the other hand the mother, comma, although uh, working as a domestic help with uh, domestic help, comma, has not yet remarried and can take better care and devote more time to the child. Full stop. We do not find any illegality as such with the impugned order insofar as the refusal of uh, custody to the father, appellant father outright is concerned. Full stop. However, comma, we admit the appeal for being heard only on the question as to whether the appellant father is entitled to visitation rights to the minor son, and, comma, if so, comma, as to what should be the timings and modalities of such visitation. Full stop. Next para. The appellant shall serve copies of the memorandum of appeal and can 1 of 2025 on the respondent, indicating that the applications shall be listed under the appropriate heading on June 16, 2025, when an affidavit of service to that effect shall be filed. Grateful, madam.
I am paying for only short passover, my lord.
You move the matter.
Lordship, I am for the
Move the matter. Move the matter.
Lordship, I have filed the Vakalatnama today, my lord.
So what? No difficulty.
My lord, I have not received the memorandum of appeal.
I have
You have received a copy of the application.
I have received the CAN applications, 2 applications.
You're entitled to only that under
but the
order
main application is
under
not
under section 148. You're entitled to only that.
This is a section 5, my lord.
Yes. What is the delay?
This delay, my lord, 156. Delay, my lord, my lord. I'm for the husband, my lord. My lord,
This is against a divorce decree.
yes, my lord. Yes, my lord. When I came to learn about the decree, my lord, from my daughter, my lord, on my lord, 20 March 2025, my lord. In spite of having knowledge of my residence, my wife did not include the present address, my lord. But my lord,
Yes. What do you say to this?
My lord, actually the degree has been passed by the lower court in this case, and the final degree has been passed, my lord. All the procedures has been maintained by the lower court, my lord. And at this juncture, he is saying that, my lord, he is staying somewhere else and given some receipts of rent to suffice that he is saying staying somewhere, my lord. This will not stand here, my lord.
I have annexed.
It's not maintainable, my lord.
2022, my lord.
And my lord, moreover, my lord, 158 days delays, which has been said by the
yes, annex the rent receipt of the other address.
Yes, my lord, that rent is also defective, my lord. Kindly peruse. Kindly peruse, my lord.
What is the defect?
Oh, my lord, kindly see the date.
Take your own copy.
Kindly see the date, my lord.
Yes. What was the date of the decree?
Date of the rent receipt is 31st of March 2025. Okay, that 2025. Just let me submit. Let me submit. Page number 8, my lord.
There is no page number 8.
Page number 8, my lord. The date is on.
There is no page number 8 in our copy. Page number 6 and 7 are the annexures.
7, my lord.
7,
my lord.
7, my lord. And the 8 is all 8 is also affixed in this, my lord. This CAN application. It has to be also, my lord. Kindly be seen, my lord.
What has to be annexed?
In 8, page number 8, my lord, of the
Yes.
CAN application.
Yes.
Kindly see the date of the.
Date on the top does not tally with the bottom.
Yes. And my lord, it is totally false, my lord. I will say at the time of hearing, my lord.
Hearing of what?
Hearing of the main, my lord,
appeal.
the appeal. And second thing, my lord, 158 days delay. No reasonable cause is there. Only saying that I am staying somewhere else, and I will show, my lord, that in the Aadhaar card, in the PAN card of the other side, the thing has been actually in true sense put it there. And now he is saying that I am staying somewhere else.
Yes, my lord. My wife knows the fact that, my lord, I did not
The
stay
total
there,
case
my
has
lord.
been
And
done, my lord. So long the case has been done, all procedures has been maintained, and now he has come with a plea that I am staying somewhere else and the degree has been passed ex parte, and this is the reason, my lord.
no notice of summon, my lord, has been served upon the
The
husband.
daughter,
So,
your
but
daughter
all
resides with the mother.
Yes, my lord. Daughter and son reside with the mother, my lord.
For purpose of Section 5, a sufficient ground has been made.
Lord, if my lord admits
But
that,
we'll
I
say
don't
that
have to
we are not, these observations will not affect the final hearing of the appeal.
My lord.
Because these also have some bearing on the final hearing. We'll make that clear.
My lord. My lord, kindly direct them to serve me the memorandum of appeal.
We will direct them to serve. You will prepare the paper books.
No, my lord. Till now, I
You will
have
get it in the paper book itself. They have an injunction also. Let us first allow the Section 5. The application for in the application for condonation of delay, the appellant husband has pleaded that he was not aware of the ex parte decree passed in the divorce suit filed by the respondent wife, from which the present appeal arises, before being informed of the same by his daughter, who resides with her mother, the respondent, on March 14, 2025. First up, it is contended that the appellant husband had been residing at the relevant point of time in a different place than that shown in the cause title of the plaint of the divorce suit. First up, as such, proper service was proper service of the summons of the suit were not effected on the appellant at all. Proper কথাটা দেবে না. Service of summons of the suit was not effected on the appellant at all. Push-up learned counsel for the appellant places reliance on the two rent receipts annexed to the application to argue that those show that the husband is residing in a separate rented accommodation than the address shown in the plaint of the suit. Push-up next para. Learned counsel appearing for the respondent denies such allegations and submits that the summons of the suit were served properly. Full-stop. It is pointed out that in the second rent receipt annexed to the present application, the date at the top right-hand corner of the purported rent receipt does not tally with that at the bottom. Miss Chatterjee.
My lord.
No.
My lord, page 6, my lord, that is issued on 2022, my lord, July.
Yes.
Genuinely, my lord.
None of them are genuine.
My lord.
The second one, it was issued for the month of March 25. He signs.
25, my lord.
He signs on.
He is residing there, my lord. My lord. He is residing there, my lord, in this address, my lord.
Does not tally with the date accompanying the signature at the bottom. Push up next para. Upon a careful consideration of
Lordship, can I say a thing, my lord? Lordship, no Aadhaar card or no such documents has been annexed.
You file an opposition to this.
Kindly, have a line, my lord. Only a line, my lord. I will say it.
No, we'll give you opportunity to file an opposition to this. We are not allowing it. You are right. While considering, we are finding it. So next para. It transpires from the annexures to the present application that although the first purported rent receipt annexed at page 5 thereof carries proper dates, tallying with the month for which the rent was purportedly paid, the second purported rent receipt is suspect. Full stop. Not only the date at the top right-hand corner of the said rent receipt, annexed at page 7, not tallying with the date accompanying the signature, the year of the date accompanying the signature of the author of the said rent receipt at the bottom, the month has been shown to be, the month for which rent was paid has been shown to be March 2025, which also does not tally with the signature. Full stop. As such, some doubt is created about the veracity and authenticity of the said documents. Full stop. That apart, it is rightly pointed out by learned counsel for the respondent that apart from the said rent receipts, comma, which have not been properly proved, comma, no other corresponding document of residence elsewhere has been furnished by the respondent by the appellant, comma, including his Aadhaar card, comma, voter ID card, comma, etc. Push up. Since the respondent has raised certain relevant issues, comma, we direct the respondent opposite party to file an affidavit in opposition to the application. Within how much time can you file it? You are Mr.
Lordship, I am Narendranath Malakar.
Mr. Malakar, how soon can you?
Lordship, fortnight after the vacation, any date.
Within June 20, 2025. Full stop. Reply, if any, shall be filed by June 27, 2025. The application shall be listed on July 1, 2025 under the appropriate heading.
Lordship,
Prathame affidavit of service filed to be kept on record.
Lordship, a copy of the memorandum of
Memo not right now. Oh. Injunction application have you served?
Yes, my lord. Yes, my lord. I have served both the applications.
You are entitled to only those two. Anyway.
Lordship, in item number 21, Lordship, I am praying for a short passover, Lordship.
Sorry.
Number 21, Lordship, I am praying for a short passover.
Why?
Lordship.
No short passover.
I'm late by Mr.
That concept is now obsolete after the first two short passovers granted in the morning. You are sufficiently competent, you have to. What is the matter about Mr. Orji?
I have filed two applications. One
You are led by Mr. Oyan Banerjee.
Lordship, I am late by
You will contest the matter. You have a copy of the application with you. Do you know what is the application about? Very good. Take it out. Yes.
Well, two applications has been filed before your lordship. One for temporary and permanent injunction, and second one for mandatory injunction. There is the appeal arising out of the revocation of a will, of a probate. I have challenged this order before this honorable court, and in the meantime, I have been compelled to take out these two applications because they are an apprehension of selling out this property to any third persons.
Why mandatory? What mandatory?
Mandatory because, my lord, I was in position. My tenants were in position. They have been thrown out from the position by some local goons with the help at the direction of the respondents, and they have put the padlocks on the
Is that after the filing of the appeal?
Yes, during pendency of the appeal.
Mandatory injunction will consider at the final hearing stage. Temporary injunction we are granting at interim.
Lordship, may I?
Yes.
May I? Lordship.
So what is the temporary injunction you have sought?
Well, only that no third party interest may be created.
Yes, what do you say?
Only thing, Lordship, the prior to filing of this appeal, we have the respondent opposite party number 1 has filed a title suit for declaration and injunction.
I have stated in my application.
And it has been decreed on my favor. The respondent have contested. This is the judgments, Lordship.
Declaration and injunction.
No, but I'm saying.
Let him complete.
Yes.
He has to complete first. Yes.
Lordship, declaration and injunction. If your Lordship may kindly take the ordering portion, Lordship. Lordship, may I just first take
You are Mr.
Huh?
What is your name?
My name is Dhiman Banerjee.
Mr. Banerjee, please address into the microphone. Yes. Expert degree, yes.
May I take your Lordship to the first page, last paragraph, Lordship. The summons of the case has been duly served upon the defendant, that is respondent Pratima Ghosh, whose son is the appellant herein.
No, that is their allegation. You must, according to you, when did they take possession?
Well, in the month of October 2024.
But they have this decree in their favor.
Well, I'm saying, suit was filed. My mother was contesting the suit. Unfortunately, mother discontinued due to ill health. The suit has been decreed ex parte. My mother during her lifetime filed an application under Ordinance Rule 13 for setting aside this application. This application, my mother deposed before the learned court below. My mother contested the same. After demise of mother, I have got entry in the case. This case is still pending. During this continuance, my lord, they have forced. I bow down before lordship. There is a decree. But there is some procedure for getting possession of the decree even after passing of the decree.
This is not a recovered of possession decree.
No.
This is a decree.
They have forcefully done
this. This is a decree of permanent injunction where it has been held.
No, that was a
Mr.
shoot for
Banerjee, let him continue. You just help him.
but that was a shoot for recovery of position also. They are saying that there is a recovery of position.
Recovery of position. Acha.
There is a recovery of position. And not only that, they have said that as I have mutated with the Varnagam municipality, so I have the right, I can do it whatever I want. But in the year
If they
2014,
file their opposition, we'll consider it on merits.
but in the meantime, the interim prayer I pay.
No, that will grant. That he will not transfer
Lordship,
create third.
Lordship, only
Mr.
one-
Banerjee, you will not create third. Yes.
Only one thing, Lordship. We are owning the property by virtue of a registered deed of settlement that has been
Save those things for your opposition.
prima facie case has not been made out, Lordship.
What?
We have
What prima facie case?
Mr. Banerjee, you take over. Yes. What prima facie?
For getting the injunction, my lord, they have to show, my lord, if the probate is granted, my lord, they will have, my lord, ownership of the property. This property was settled by a registered instrument prior
No,
to, my lord.
probate was granted to them.
Granted to
Probate
them.
was
You
granted.
obtained a revocation.
I obtained a revocation. Irrespective of the probate, my lord, there was a prior, my lord, a deed of settlement in my favor, by virtue of which, my lord, I became the owner. I filed a suit for eviction against them. There, I obtained a decree. They appeared, filed written statement. I obtained a decree. Now, that is not a judgment. So, where my title over the property has been not, because without that,
His order 9 rule 13 is still pending.
that is
Yes.
pending. That is pending. Therefore,
But the decree is there.
Next year
Decree
is
is there.
September.
So therefore, we cannot say that we cannot decide right now at this stage at
Now,
least whether
in this proceeding,
whether
if
they were in possession.
if they get probate, kindly consider this. Not if they get probate also.
No, my lord, my submission
my,
before the
my suit prior
Sir, this is not a COVID lorry sort of thing. Please take your seat. There is a seat behind you. Use it.
on the basis of
Please take your seat, Mr. Bhattacharya.
on the basis of the registered instrument of settlement, my lord, my title has been declared by the civil court. Order 9 rule 13 is pending. So, my lord, he can ask for a stay in that
Declared.
proceeding.
But Mr. Banerjee, we won't give you a clue as to what to put in your opposition. We won't advise you on that. But his specific allegation is that although there is a decree, that decree was not only for declaration, recovery of possession, and then permanent injunction. Therefore, you have to show they are saying that you ousted him without due process of law, not in due execution of that decree. That is his specific case. So you have to deal with that. So at this stage, definitely there's an arguable case. We find prima facie case. Learned counsel appearing for the petitioner submits that the present appeal arises out of the grant of revocation of a probate. Full stop. Next para. It is submitted that taking undue advantage of the decree, comma, the respondents are attempting to create third-party interests in the property. Full stop. That apart, comma, it is argued that the appellant has been ousted from the subject property without due process of law, and as such, comma, a mandatory injunction has also been sought in Can 4 of 2025 for restoration of possession of the appellant in respect of the subject property. Full stop. Next para. Learned counsel appearing for the respondents submits that no prima facie case for injunction has been made out. Full stop. Learned counsel hands over to court a photocopy of a certified copy of a judgment and decree, a judgment and ex parte decree obtained against the appellant's mother for declaration of title of the present respondents, as well as for recovery of possession against the defendant in the said suit, that is the mother of the appellant, in respect of the scheduled property, as well as for permanent injunction. Full stop. Next para. It is thus contended that the recovery of possession was taken in terms of the said decree, which stares at the face of the appellant. Full stop. Next para. Learned counsel further seeks to rely on certain deeds. Full stop. Next para. Learned counsel appearing for the appellant submits that an application under Order 9 Rule 13 of the Code of Civil Procedure was initially filed by the judgment debtor stroke mother of the appellant, where the appellant has subsequently been substituted and the same is still pending. Full stop. Thus, comma, it is submitted that the decree obtained by the appellant, by the respondents, is in a sense in jeopardy. Full stop. Next para. We find that a sufficiently arguable case, as indicated above, has been made out by the parties to give rise to a prima facie case for grant of injunction insofar as the creation of third-party interest is concerned. Full stop. However, it would be premature at this stage to grant mandatory injunction without ascertaining whether the respondents obtain possession with or without due process of law. Full stop. Accordingly, the respondents are directed to file their affidavits in opposition in respect of both Can 4 of 2025 and Can 5 of 2025. Full stop. The parties shall maintain status quo with regard to selling, transferring, alienating, and or encumbering, and or creating any third-party interest in respect of the subject property till disposal of the applications. Affidavit কত দিনের মধ্যে বলেন না? কত দিনের মধ্যে affidavits বলেন? Such affidavits shall be filed. Affidavits in opposition shall be filed by June 13, 1 week of June 13, 2025. Reply, if any, shall be filed by June 20, 2025. The applications shall next be listed for hearing on June 24, 2025.
But grateful.
Thank you.
I'm Mr. Mukherjee.
Oh, sorry. Yes.
For the appellant petition, section 5 application is there, but your lordship on last occasion directed the FMA to be converted into FA. That order, but copy direction one from service of copy has not been given. Section 5 application.
We did not direct it to serve copy.
No,
Is appearing
subject to correction, madam.
Only reclassification was directed.
Yes.
Yes, before that we could not take up. Anyway, serve copy and come back.
Yes.
Only one connected application with the
only section 5 application, madam.
Appeal is against what, Mr. Das?
Madam, against order allowing an application under order 7 rule 11.
Achha. Your suit was for?
Suit for under section 263 of the Indian Succession Act. It was dismissed only on the ground of limitation. But there are several
1677 days delay.
This case, before that, I filed a revision application against the order. That order had, when it came for final hearing before Honorable Justice Ajay Mukherjee, his lordship directed the matter to be converted.
You had the advocate on record there?
No, man. Gopal Ghosh.
Then, Mr. Gopal Ghosh? Then it cannot be said to be a bona fide mistake. Not section 14. We'll take judicial notice of the fact that this is the senior advocate, Mr. Gopal Ghosh.
My lord.
We'll take
he's junior.
We'll take judicial notice that they had sufficiently good legal advice.
Well, he's junior, he's there. Huh?
Yes.
Wrong forum.
We don't go by stray comments.
No, not stray.
We don't go by stray comments.
And thereafter it has been transferred.
Mr. Das will have to produce the orders, at least the order copies of justice.
Yes. Supplementary affidavit. But in the meantime, your lordship, if your lordship direct to
service will direct.
Yes.
The explanation given for the huge delay of 1677 days is primarily the pendency of a revisional application by error. Full stop. The appellant shall furnish the relevant papers, including the server copies of the orders passed in the said revisional application at the time of final hearing of the present application. Full stop. The appellant shall serve copies of the application on the respondents, indicating that the application shall be listed for hearing on June 16, 2025, when an affidavit of service shall be filed by the appellant to that effect. Next. Yes. Yes, Sumitra.
Well, suit for declaration and injunction, declaration that I am the absolute owner of the suit property, and my lord, permanent injunction. Now, injunction application moved, interim order passed restraining the defendants from interfering with my position. The defendants appeared, some of them. They appeared, they filed written statement, did not contest the suit. Then, my lord, the interim order was, my lord, confirmed in 2020. That was continuing. The suit has been dismissed. It's from the appeal is from the decree. And my lord, injunction application is before your lordships, my lord. May I show your lordships, my lord, the order?
Possession, is there any finding that you are in possession, or it has been disbelieved that you are in possession?
No, it has not been disbelieved.
Neither found in your favor.
No.
Possession,
I really, my lord, no, possession, in fact, my lord, the written statement also possibly, my lord, does not, my lord, dispute that, my lord, I am in possession.
that is the only injunction you have sought.
Yes.
Mr. Mitra, please show us from the written statement that or your plaint, because possession or the finding of the trial court, because possession status quo, we are not a believer in status quo.
No.
You know the reason, Mr.
No.
We are deprecating every day.
So
Status quo, unless we record that who is in
if
possession.
your lordships are pleased to come once, my lord, to page 286, my lord, that was the interim order which was continuing.
All right. We'll just only look at the final degree because it has now merged.
Yes.
We are satisfied on that, Mr. Mitra, that you had made out a prima facie case in the court below regarding possession. Whether there is any contrary finding, just
no, there is very well, my
no.
lord.
If you say there is no contrary finding, we'll go
kindly,
back.
my lord, kindly look into, my lord. The finding, my lord, starts, my lord, the internal page 5. Decision with reason.
One page.
Yes.
Ratio.
Yes. Yes. On careful perusal of the unchallenged testimony and
yes, Mr. Mitra, we have seen. In view of a strong prima facie case for hearing the appeal on merits having been made out, and since the plaintiff stroke appellant plaintiff stroke appellants had continued to enjoy an order of injunction during pendency of the suit, we are of the opinion that in the event the ad interim prayer for injunction is refused at this stage, there is every chance that the appeal may be rendered infructuous. Thus, the parameters of grant of ad interim injunction have been satisfied. Accordingly, the respondents stroke opposite parties are hereby restrained by an order of injunction from disturbing the peaceful possession of the plaintiff's appellants till disposal of the application. The appellants shall serve copies of Can 1 of 2025 on the respondent stroke opposite parties, indicating that the application shall next be listed for hearing on June 16, 2025, on which date an affidavit of service to that effect shall be filed by the applicant. Please give your names. Ask somebody to give your names. Yes.
But I am for the plaintiff, my lord. This is the first
No,
appeal, my lord.
the difficulty is I have a different special bench at 12:30. So we'll rise now.
My lord, then my lord,
from 2 p.m. we will continue.
Yes.
2 p.m. I have a two matter. No, that is a 1 matter, 2 matter bench, Mr. Prakash. And we have indicated in the list that this will resume after that. Very short matter. We'll take up division bench after that. Mr. Basu, keep some learned friend will definitely. You need not say that. Yes. We'll take up division bench after recess. Immediately after that, 1-2 matter is over.
My lord, I will be leaving the court for the time being. My lord, I will come back by 2.
At your own risk.
Yeah.
Calcutta judges are sitting
Single bench.
My lord, may I have your lordship's kind leave to mention
No
what?
mentioning now. No. Yes.
Before my lord takes up this matter, that is my learned friend serves a copy upon me or my client. I am appearing for the opposite party enforcement directorate. I am led by Mr. Raju A. Learned ASG online.
You have got a copy?
No.
No, we have not got a copy, my lords.
We,
We have not got a copy.
Yes, what is the matter?
my lord,
I am appearing for
Mr. Agarwal will address your lordship. I think, my lord, subject to what your lordship says, we do not serve a copy and we move this ex parte. That is the rule. In fact, if we serve a copy, it's to the detriment. The court might just take umbrage of that. It's criminal
What
revision.
is detriment? How can there be a
Let
detriment?
Mr. Luthra argue on this and Mr.
on the procedural aspect, on the procedural
Yes, this is the corresponding provision of 340. Yes, unless we form a prior official opinion, how do we give you a copy?
Yes.
If you get a copy, I mean, the omen is bad for you.
No, my lord will kindly allow, if after hearing, definitely after
Yes,
hearing.
only if you form a prior official opinion, then
your lordship will kindly.
then also you don't have a right of hearing.
My lord, yeah.
We'll direct proceedings to be initiated. This is between the court and them. I mean, they will just point out to the court, and court will of its own opinion.
My lord,
There's
only
no
one,
scope.
only one humble prayer, my lord. If after hearing my learned senior friends opposite or their senior appearing for the
Yes.
petitioners online, if your lordship finds that there is
Scope
any
of explanation.
any scope for passing any interim order. So for that, my learned senior, Mr. Raju, may kindly be hard on.
Very well.
Very
Definitely. Yes. Yes, Mr.
Lord, I would be
Mr.
appearing
Luth-
for the de facto complainant.
I mean,
But I do not know whether
Lord,
De facto
we have only
complainant, you
pointed out
don't have
this.
any right of hearing. Yes. Yes, please.
Item
If
4.
there's an interim order being passed against me, I suppose I have a right to be heard if there's an interim order being passed against me.
Mr. Raju, is there any scope of interim order in this sort of a matter? Either we have to form an opinion and direct investigation.
Yes, therefore it has to be heard. It is not as simple as it is. Mother, the issue is this. My
If
lords
we
have
require
heard
a, if I require a clarification, Mr. Raju, definitely I'll hear. But
But I
it's
only-
entirely on the discretion of the court.
I only point out this, my lord. Their entire case is based on the fact that earlier order where my lords have stated the predicate of it. my lords.
Very good.
I would
Very well. Let us hear the petitioner first. Yes, yes, Mr.
Item number 4, my lord. Mr. Luthra will be leading. Item number 3, Mr. Agarwal will be leading. I believe item number 4 will be taken up first, and then item number 3 will follow. That is what we've been told.
Then we'll take up 4 first.
Four
Mr.
first, my lord, and
Luthra,
then
please. Yes.
Lord, I'll put it to your lordship very simply.
Item 4. Sorry. Yes.
Item 4. Now, Lord, very simply, Lord, what is the issue?
Is there a problem?
Mr. Luthra's connectivity is disrupted.
These are matters which relate to a prosecution. Lordship, can your lordship hear me, Lord, now?
Now,
Can you
yes.
hear me, Lord? Yes, Lord,
Now,
I
yes.
see the point. Yes. Now, Lord, I'll tell your lordship simply. There are 4 petitions here before your lordship today, all
Yes.
represented by different counsel. And all of this arises in relation to a scheduled offense, which is on a complaint by SBI on 29th of August 2022.
Yes.
Now that complaint is already here, P10 at 164. That complaint, if your lordship recalls, said that the cause of action arose in Calcutta only. And yet when the CBI chooses to register an FIR, Lord, they choose to bring in the term Bhubaneswar, knowing that they don't have consent under the DSP Act to investigate offences in West Bengal. And they make up the facts. They inform the court also in Bhubaneswar. So everything has happened in Calcutta. And the complaint talks of Calcutta. And
Right.
based on that, when the matter came up before your lordship, this court was pleased to consider the matter and pass an interim order. Now that's the one part. That order has been passed on the 2nd of May by your lordship, which is at page 385, annexure P29. Just have a look at that for a moment.
Can you give the page number, please, again?
385, my lord, P29, annexure P29,
Right.
at page 385. There are a number of writ petitions moved. I'll just place that.
Yes, 385. Yes.
389, Lord, 385, yes, I have 85, I'm sorry. P29.
85.
Now,
Yes.
Lord, if your lordship is kind enough to see, the argument is captured in para 2.
Learned senior counsel appearing for the petitioners contends that the present investigation is going on at the behest of the CBI in contravention of provisions of 5(2) read in conjunction with Section 6 of the DSP Act, for short the 1946 Act. It is pointed out that in terms of Section 6 of the Act, nothing contained in Section 5 thereof shall be deemed to enable any member of the Delhi Special Police Establishment to use powers and jurisdiction in any area of state not being a union territory. On the other hand, Section 5 stipulates that the central government may by order extend to any area, including railway areas in a state not being a union territory, the powers and jurisdiction of members of the DSP for the investigation of offences or past offences. Subsection 3, it is contended, provides that where any such order under subsection 1 is made to any area, then without prejudice to the provisions, any member of the DSP or above of the sub-inspector may, subject to orders with the central government, may exercise powers of an officer in charge of a police station, etc. Now, Para 5, learned senior counsel submits that by notification number so-and-so, dated 16 November, the government of West Bengal withdrew its consent as accorded within the contemplation of Section 6 to all members of the DSP to exercise the powers and jurisdiction under the 1946 Act. Learned senior counsel points that the genesis of the impugned report was the complaint lodged by R4, the deputy manager of the State Bank of India. Since the complaint was lodged in Calcutta pertaining to an event allegedly in Calcutta, which falls within the state of West Bengal, in the state of withdrawal of such consent under Section 6, the entire investigation and initiation of proceedings pursuant to such complaint by the CBI's bad law, then got similar contention in Para 8 made, and then in Para 9, 10, etc. All of this is not stated. Then just comes straight away to Para 12, where they say, it is submitted by learned senior counsel appearing for the petition that in stark contravention, although the complaint was lodged in the FIR, report was filed surprisingly before the Special Court Bhubaneswar. Then Lord Para 13, 14, etc. Lord, it goes on. And the argument made on the other side was that part of the cause of action arises here. Then if my lord just comes to Para 23, your lordship say upon hearing the learned counsel for parties, I find a strong prima case for hearing the petitions on merits having been made out. Insofar as territorial jurisdiction is concerned, it may be noted that internal circular issued that too merely for so-and-so cannot override the law as it stands. And your lordship in Para 26 and say that prima facie case made out. And finally, your lordships state the proceedings. Now, Lord, please see the nature of the stay that was passed. If my lord is kind enough just to see 45. Para 45.
Yes.
Para 45, Lord. Accordingly, in view of the observations, paid 400. Accordingly, in view of the observations, there shall be stay of all further action taken on the basis of and continuation with the investigation initiated in connection with RC 1 dated 6 September 22 under the section mentioned till 31st July or till further order. Now, Lord, let me come back to this. So very simply, Lord, for invocation of jurisdiction under the Prevention of Money Laundering Act, there is a mandatory requirement that there be what is known as a scheduled offense or an offense described in the schedule and meeting the financial criteria. Without such a scheduled offense, there can be no invocation of power under the PMLA Act, because the invocation of power is dependent upon the term proceeds of crime, and that term proceeds of crime is dependent upon the existence of a scheduled offense giving rise to a crime. So that's the first crucial part. To put it simply, Lord, in other terms, the foundational fact of investigation or invocation of power, statutory power under the PMLA is dependent on the foundational fact of an existing offense under a scheduled offense, which is occasionally called predicate offense, depending on the jurisdiction we are in. So that's the first. Now, what has happened in this case is, after registering the ECIR on 24th March 2023, on 15th of February 2025, despite the fact that on 15th of February 2005, they go and file a prosecution complaint, and that is not the term that is normally used in ED parlance, which is available, Lord, here. I'll just give your lordship the page number for a moment. Ma'am, just the complaint. The order, Lord, is available at 342. My learned friend points out. Just allow me a moment. Just a minute, ma'am. But it is the prosecution complaint, the certified copy has been filed at the end of the paper book. It's filed on 15 February 2025. My friend, Mr. Sabyasachi will just point out, not that page number.
Yes.
It is absolutely at the end.
This.
Absolutely at the end, your lordship would see
This one.
that one.
Just prior to that.
Yes.
Now, Lord, this complaint is filed. This complaint is filed. And if your lordship is kind enough to see page 4,
This is an order. This is in the
Just
form of
prior
an
to
order.
that.
Just
Just
prior
prior
to
to that.
Prior to that.
That's the entire bunch of certified copy.
right.
Well,
right.
just starts from immediately after page.
The certified copy opens with that.
Yes, this is the opening page. Your lordship would see after your lordship's order. Your lordship's order was there. Immediately after your lordship's order,
Really, yes.
it starts.
No, Lord.
Right.
Now,
Yes.
your lordship got that. Now, Lord, your lordship is kind enough to see at internal page 4 of this, the title is Complaint under Section 44 and 45 of the Prevention of Money Laundering Act. And kindly note, para 1, FIR complaint number of police report under 173(2), nature of scheduled offences and place code where it is being tried, FIR number RCBSK 2022E01 dated 6 September, which is the very same FIR which is the subject of your lordship's order on 2nd of May 2025. Where your lordship,
Yes.
it is without jurisdiction. Now let's put, there are two aspects which I must place before your lordship. First aspect, Lord, and that's the one which is that the original offence investigation being stayed has been found without jurisdiction prima facie, of course. Could they have proceeded with the ECR? Could they have filed a complaint? Can the complaint be allowed to proceed? But there is a more interesting proposition, Lord, which is equally interesting, I should say, not more interesting. Lord, your lordship is conscious that last year we decided to do away with what we thought was the CRPC, but brought it in a new avatar called BNSS. Now, the BNSS is really a
Recasting
version of the CRPC.
Yes.
Recasting, Lord, recasting the numbers have changed. It only makes lawyers work a little harder, and we trouble your lordships also with the provisions.
Yes.
But otherwise, the younger generation will find it here.
Right,
We have
right.
our own complications.
True.
Now, what happens, Lord, when the numbers change, a very interesting provision is added, and your lordship knows that there is that natural justice is something which is natural justice, and the presumption of innocence are something which are basic to criminal jurisprudence. It's part of my Article 21 rights. Now, at various stages, the traditional view has always been that at the stage of cognizance, because as your lordship knows, in a criminal proceeding, there will be 4 stages. One stage is 190, which is CRPC, which used to be cognizance, when the magistrate or the judicial officer or the special judge or the session judge applies their mind to see is an offence committed or not. The second stage is the summoning stage, when you can issue a summons or warrant, which used to be the old 204 CRPC. I'll give my learned friends will give the details of the new provisions, Lord. I keep telling them I'm a fossil, so I keep tend to refer to the old provisions. It's now, I believe, 227. Now 227.
Yes.
Now, what happens is, Lord, the second stage was summoning, when the court sees, all right, there's an offense I found out. But who do I proceed against? Do I proceed against the people named? Other people, some of the people named? That is an application of mind again. Both stages, there is an application of judicial mind by the magistrate or the special court. We'll call it magistrate for you. Now, the third stage, of course, will be at the stage of consideration of charge, where the court now has the opportunity, traditionally, to hear both the accused who have been summoned, as also the prosecution, and to determine that on the existing material, should I proceed or not proceed further, or should I drop the proceeding, what we call discharge colloquially, under the CRPC, which used to be old 239, 240, or 227, 228 CRPC. Now, what has happened is not. Now there has been, while the recasting happened, there was a reconsideration or an application of mind by the law drafters, and it seemed by the lawmakers as well, who felt that this issue of the use of criminal process, whether by agencies or by individuals, is now becoming rampant, and too many people, and when I say too many, not just too many people, are being subjected to criminal prosecutions and harassment. And why should they not have a right to go and tell the magistrate, don't do this. If my lord recalls, there used to be this line of decision, which was K.M. Matthew, which said that you can go to the magistrate and ask for dropping of proceedings. That was 2 judges way back in 2002. Then we came to the decision in Adalat Prasad and Subramaniam Raman in 2004, where the court said magistrates do not have inherent powers. Your lordships, under the old code 1898 under section 561A, and thereafter in 482 and now under 528 have that power of inherent powers. It has been preserved, but the magistrate did not have it. So to obviate this situation, there is a very interesting development which is legislatively taking place. And may I draw this court's attention to section 223 of the BNSS?
Yes.
This lot is the introduction of natural justice, Article 21, for the first time legislatively in a criminal proceeding before the proceeding can move forward. Now, please let's look at 223 together. May
Yes.
I your lordship's permission?
Got it.
The title is Complaints to Magistrate, Examination of Complainant. A magistrate having jurisdiction, while taking cognizance of an offence on a complaint, shall upon oath the complainant, examine upon oath the complainant and the witnesses present, if any, and substance of such examination shall be reduced to writing and shall be signed by the complainant and witnesses and also by the magistrate. But this is really the equivalent of the old section 200, which your lordship will find possibly mentioned. I hope if we have the same book, it will be mentioned at the bottom of that. However, the proviso is the game changer.
Yes.
The first proviso is very crucial, my lord, because this is the introduction. The second proviso, which is now the second proviso, always existed, but the first proviso is there, provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. So the question is, 223 says, before taking cognizance, you will not proceed without hearing the person who is accused. Give them an opportunity. By way illustratively, not if the accused can say no offense is made out, or there is a statutory bar, let us say not sanction, or there is a jurisdictional bar, then the magistrate ought to hear the accused rather than allow the perpetuation of an illegality or a jurisdictional error, which will then have to be corrected at a later stage, either in the proceedings or by the High Court. Thereby, the idea is to try and do away with a lot of lapses that would occur as a procedural level. In fact, Lord, there's a decision of my Lord Justice Shanta Government Lord just before we lost him, Krishna Lal Chawla, we interesting decision on a separate note. I'll place the citation before your lordship, which said that magistrates must be vigilant because they should ensure that abuse of process is not allowed to occur. That's a 2022 decision, I believe, not 22 or 23. But the point I'm seeking to make is that that principle has now been culled out and introduced in the CRPC. Now, in this case, Lord, it's a very, and if my Lord is just kind enough to see the order for a moment that has been passed. Just a moment.
After the complaint, the order is that last 4 pages.
But just see that for a moment. Just so that. Hey, it's a 342. Now, my Lord may just see.
Yes. Yes.
This is the order that has been passed.
2025.
15/2/2025. Does your lordship have it?
I do.
Record is today put up on the basis of filing of one petition along with one complaint in connection with ECR number so-and-so. Then not the first para talks about the complaint. Please come to the second para. On perusal of case record, it transpires that complaint has already been registered as PMLA complaint ML case number 12 of 24. Then not the learned special prosecutor for the EPP's arguments are recorded in the next 3 or 4 paragraphs. And please come to the internal page, not this should be possibly second last page, where it's on the 4th line from the top.
No opportunity of hearing given, Mr. Luthra.
Yes, Lord. No opportunity of hearing given. Not all it says complaint also praised for taking cognizance of money laundering.
Yes.
So the complainant never pointed out that now you have to
for ED and right.
yes,
Component
Lord.
and
Now these are the two issues, not which I wanted to flag for your lordships. Now, if I may just not fine tune it a little more, to put it simply, that once your lordships in para 45 stays the proceedings, I would submit not everything is to go on a simpler note, not based on this alone, because there are two issues that will arise. If the proceedings by the CBI are void ab initio, beyond jurisdiction, there could be no question of an ECI, there could be no question of a prosecution complaint, because the prosecution complaint has to go in line with the Buller principle of 2011 not to say that if the basis is bad, every consequent action has to fail. That's para 107 to 107 to 111 of Buller. Now, that being the position, Lord, that is one point. The other point I have already placed before your lordship on the absence of consent, and 223 I have placed. If your lordship desires not, I can place on record a few illustrative orders, but this is what I had to say essentially.
So the first point, Mr. Luthra, is that this was in the teeth of the order of this court, stay order.
Yes, my lord.
Second is that the foundational fact of PMLA were not met.
Cannot be met because if your lordship's view in your previous order was that prima facie there is no jurisdiction with CBI to act. If there is no jurisdiction, there could not be a predicate offense registered. If there can be no predicate offense, there is no question of them proceeding to ECIR or prosecution complaint. And that's the jurisdictional fact. For that note, your lordship knows the classic decisions.
And also 223 violation.
Yes, Lord. And I must just point out not just one thing.
Yes.
Just as an illustration, Lord, there are in fact orders in similar cases. Not I'll just point out, Lord, there were orders passed by your lordship's coordinate bench, and I'll just point those out for a minute. Just show me orders. Coordinate benches in the past, Lord. Just let me just pass that over. My lord, there are two orders. One is an order in CRR 2087 of 2022, Lord. 1st July 2022.
Are those annexed, Mr. Luthra, or you will be citing?
Lord, my learned friend will tender them, Lord. My learned friend will tender them. There's two of them, Lord.
Till now, he's tendering only apology.
Not yet. Just a minute. Mr. Bhattacharya has the paper.
Mr. Ayan Bhattacharya was with me last evening, and I thought that I had assisted him well. Clearly, I'm failing.
There's a miscommunication between Bhattacharya and Banerjee.
I wasn't there, so this part just gives me 1 minute. But I'm sorry.
What is the moot question? The proposition?
Moot question in both the cases was that where there is a stay of proceeding in the CBI case, then the ED proceedings ought not to be allowed to continue, Lord. There are two cases. One is the order CRR 1765 of 23 of 11th of May 23, Lord, and the other one. And not there, Mr. Bhattacharya had the privilege of appearing along with him. So should be conscious of that. And the other one was not CRR 2087 of 22. There again, Mr. Bhattacharya was there. It's 1st July 2020. The July 22 order is cited in the 11th May 23 order. Just tender these, not. That's all I have to say. Not, I'm not going to go into the larger issue as to the principles in Vijay Madanal, etc.
Mr. Luthra, I think the ED should be heard on this. ED and the complaint should be heard on this.
Predicate offense is not. Sorry. I'm sorry.
I leave it, but not all I'm saying is perhaps Mr. Agarwal will throw some further light, so the ED will have be able to deal with
Mr. Raju, you are for ED?
Yes.
We'll come back to you after Mr. Agarwal throws some fresh light on this, so that you can comprehensively deal with both. Right, Mr. Luthra, thank you very much, and Mr. Agarwal, please come.
Grateful, my lord. Deeply.
Thank you so much.
I will only, my lords, take 2 minutes in supplement since your lordships have very patiently heard the issue.
Yes, please.
I can't add, my lords, anything to what Mr. Luthra has already said, but as your lordships have seen, two issues, both independent and each of them by themselves sufficient to carry my petition through to its logical end. Because I will focus on the 223 issue first. That with reference to, Lords, this principles of natural justice that have been read in, this is a position now which has become clearer And Mr. Raju is here, there's nobody better than him to guide us on this.
Yes.
Because Mr. Raju, it's very infrequently, that we cite an order of a trial court before your lordships. The reason why I seek to cite that order is because Mr. Raju embodied fairness in that order, and on behalf of the Enforcement Directorate, requested the court that the court must issue a.
I don't agree, my lord. You may give me all that accolades, but that doesn't mean I agree.
Well,
I don't agree.
Yes. I can't place it better than reading the order.
No, very well. Yes.
I was not there. If I request my learned friend to pass on a binder.
The particular order is flat in this company.
I am also given to understand that the Honorable Supreme Court has settled this issue with in the presence of the Enforcement Directorate in my favor. But despite that, or irrespective of that, the order which I was wanting your lordships to see is at page 20 of this binder, which your lordships
Yes.
flag. Your lordships will see the presence of counsel.
I've seen the presence, yes.
That's right. No? Your lordships will then come to paragraph 6.
Yes. Yes.
Where the submission of the learned ASG is recorded. That learned ASG appearing for the ED has submitted that the agency has no objection to the issuance of such a notice, and the procedure specified in section 200 to 204, corresponding provisions in the BNSS being 223 to 227, is liable to be followed in complaint cases under the PMLA by virtue of decision of the apex court in Tarseem Lal versus Director of Enforcement. The Tarseem Lal effectively said that all PMLA cases will be treated as complaint cases, and the CRPC 200 to 204 will apply. Because in this context, then the learned special judge in Delhi proceeded to analyze everything and pass it. So I'm only indicating this order to say that it cannot be that the law for certain accused persons in certain jurisdictions will be different, and the law which has not been followed in my case can be allowed to be given a go by. The second, is in the same binder at page 1. If your lordships look at an order passed by the Honorable Supreme Court. This is 9th of April 2025.
Yes.
In SLP Criminal 2766 of 25. This was a case where the trial court in a whole scam case had declined such a pre-cognizance hearing at the stage of 223. The Honorable Supreme Court on 9th of April 25 had stayed further proceedings. I am given to understand that this petition now stands allowed. Unfortunately, the judgment of the Honorable Supreme Court has not yet been made available, but the Enforcement Directorate is a party. They can confirm just this much, whether it has been allowed or not. Because with reference to this aspect,
unless you give me a copy, I don't know what you're talking about. You should give me a copy, then I can confirm without the copy.
So Raju, I'm referring to the judgment of Kushal Kumar Agarwal, which Justice Oak has yesterday allowed.
That is not yet uploaded. Judgment is not yet uploaded, sir.
That's right, but it has been allowed today in Raji's.
Not uploaded. How can you cite a judgment which is not uploaded?
All right, my learned friend is right, Manoj. I am citing the stay order, which is the request that I'm making today. If my learned friend says that he does not know about that and the judgment is not uploaded, the stay order is.
I'm not saying anything like that. Don't put words in my mouth. I'm only saying you can't rely on a judgment which is not uploaded. That's all that I'm saying. Don't put words in my mouth. Sorry.
So Raju, maybe I'm.
Let's conclude your yes.
That's right. So I am definitely relying on that stay order, because at the interim stage, that's the same order that I'm beseeching your lordships to pass.
Right.
So on the other issue of the stay of predicate versus stay of, when your lordships have found an prima facie inherent lack of jurisdiction, then every step that has been taken in consequence, my lords, must meet with the same fate. Devinder Pal Singh Bhullar is the judgment of the Honorable Supreme Court, that if the foundation goes, the entire subsequent action must go. So while it is independent, but it is predicated on this particular action, and once that is stayed, the action of the ED must be eclipsed. Those are my submissions.
Just one line I have to add, that possibly both my learned seniors are appearing.
Yes.
My lord's pleasure would be to kindly have a look, the impugned order that is before your lordship. My lord would kindly see. This is just, I'm adding one more line.
That's a
The
practice.
first line.
You are not, this is not actually an impugned order. You are seeking a caution of the
Technically,
precedent.
yes. Your
So-
lordship would see the first line. Your lordship would understand. Record is put up today by way of filing a one put up petition along with the complaint in annex to so and so. Would mean-
This matter has been assigned to me, Mr.
Yes, yes,
Right.
yes.
Record is put up
The
today. Yes.
first line is record is put up today. It would effectively mean that the date of that matter wasn't there. This is being put up specially for the purpose of filing of complaint. Hence, nobody was present. By the enforcement director, by the complainant, who's the ED, nobody was there. And this is happening behind everybody. This is
So,
the
but it's
essence.
recorded in the order, hard learned special PP for ED.
No, special PP. The complaint is the special PP. It's being filed by way of a put up petition, my lord. Your lordship would see. So the public prosecutor files a put up petition
Yes.
and files it to the court behind the back of everyone. Behind the back of everyone. It is not a regular date of the court. That is what essentially we are trying to show your lordship.
Prior to the date of the order.
Yes.
We move on to order of this order 15th. This 15th February order has been specifically impugned as well in my prayer, my lords. It's specifically pointed.
It's also there. Very. Yes, Mr. Raju will move on to you. Yes.
Lords, may
Please.
kindly have a Lords. Registration of an FIR is different from investigation. Once an FIR may be necessary for investigation, but if the investigation is bad, it doesn't make the FIR bad. Now, what is the test as far as the FIR is concerned to be bad? It must not disclose an offense. It must not disclose a cognizable offense. If the FIR discloses a cognizable offense on the ground of territorial jurisdiction or lack of jurisdiction, maybe the investigating agency can be changed, but the FIR can't be quashed. Now, kindly have a look at section 6 of the DPSC. What is prohibit? Now, before I go to that, there are two judgments. If somebody comes to a police station, CBI is a police station, my lords are aware, and he comes with a cognizable offense, they are duty bound to register an FIR. Otherwise, it will be dereliction of duty. Kindly have a look at two judgments, my lord. Can you give those comparison? My colleague is there.
Yes.
The first volume is having the synopsis as well as the index.
Page 217.
And I'll give you.
Page 217 of my.
Can you please
compilation.
also give me a copy of the Delhi Police Establishments Act?
This one would be.
If any of you, either.
We-
Yes,
I'll
yes.
come to the Delhi special.
Later on. Yes. So this is which page?
217 of my compilation, my lords.
217, right. Yes, please. Yes.
I'm sorry. The past year.
Connection is being disrupted, Mr. Raju. The connectivity is very poor.
On a lighter note, Lord, the ED
Yes.
is such a good agency, they should make sure my learned friend has the best connectivity in court.
No, there are other agencies involved, Mr. Luthra, probably.
That's true.
Mr. Raju, I'm sorry, I cannot hear you. I mean, I don't know whether Mr. Luthra's client is behind that. No idea.
Lord, a moment, I'll just call him.
Can't hear him.
Delhi is disjuncted.
We don't know whether we are disjuncted. Maybe either way.
Well, there is a power failure.
There.
Yeah. At the place of SG sir.
We hope it's not an attack by somebody.
No.
I don't think
It was
so.
a high alert till a few days back.
Well, he has asked for a second, he's regaining it. He's rejoining.
No difficulty. The difficulty is elsewhere because I have my junior partner waiting because I didn't anticipate such a long hearing actually. So I was thinking whether I can put it on tomorrow. I mean, at whatever time suits you, so that I can give sufficient notice beforehand. That will not be taking up other matters till some time. Because
I have concluded, Lord. I have concluded, and if
no,
I
Mr.
will-
Luthra, as far as you and Mr. Agarwal are concerned, we are done for the present time.
Yes,
So
Lord, I
we'll
will
have
just
Mr.
call
Raju
Mr. Raju, Lord. I'm not being able to get through to him. There he is. Sir is here. Sir is back.
Very
Yes.
rarely it happens, but there is a power failure at my place. But I am logged into something.
Sir,
Somebody's.
we never want Mr. Raju to be run short of power, Lord. He is a source of our power also.
Right.
So nice. So nice.
Yes.
Now,
Yes.
kindly have a look at 217 of my compilation, 97.
Yes. I'm there. Yes.
There are 4 models.
Desktop LD514 KT connected.
The case as put forward, my lords have got it?
Got para 4, Mr. Raju, yes.
The case as put forward by the prosecution was that PW1 went to the so-and-so Narsarapet from the scene of occurrence. He contacted PW13 to draft the report addressed to the Circle Inspector of Police. PW1 was projected by the prosecution as an eyewitness who was the nephew of the deceased, and the accompanying disease when the letter went to realize dates from the letters. On reaching the police station at so-and-so, he was informed by the constable on duty, Circle Inspector, they had already received information about the occurrence and had left for the village. The police constable at the station refused to record the complaint presented on the ground that the said police station had no territorial jurisdiction, because it was certainly a dereliction of duty on the part of the constable, because any lack of territorial jurisdiction could not have prevented the constable from recording information about cognizable offense and forwarding the same to the police station having jurisdiction over the area to which the crime was said to have been committed. So the police cannot refuse to record an FIR on the ground that there is no territorial jurisdiction.
Yes.
They have to forward it to the concerned. The procedure is you record a 00 FIR. I don't know whether the same procedure is there in West Bengal. And then it is forwarded to the concerned police. In this case, it has been forwarded to the Orissa.
Yes.
Territorial jurisdiction. Territorial jurisdiction can emanate from geographical reasons or from the fact that there is lack of consent under Section 6.
Lack of consent under Section 6, Mr. Raju, would you confine it to territorial jurisdiction?
I'll make my submission. I'll make my submission, but because certain points were not raised during the time when my lords have passed the order, my lords. For now, have a look at Saldev Court's judgment.
Page 204.
Page 204 of this compilation.
Yes.
Which is the paragraph?
Yes, page 204.
210.
Now, kindly have a look, my lords.
Para 8.
Para 8. In our view, the submission made by the learned counsel for the appellant requires to be accepted. The limited question is whether the High Court was justified in quashing the FIR on the ground that the Delhi police did not have territorial jurisdiction to investigate the offence. From the discussion made by the learned judge, it appears that the learned judge has considered the provisions applicable for criminal trial. The High Court arrived at the conclusion by appreciating the allegation made by the parties that the SHO police station so-and-so Vihar Delhi was not having territorial jurisdiction to entertain and investigate the FIR lodged by the appellant because the alleged dowry items were entrusted to the respondent in Patiala, and that the alleged cause of action of the offence punishable under so-and-so or was at Patiala. In our view, the findings given by the High Court are on the face of it illegal and erroneous because SHO has a statutory authority under 156 or so-and-so to investigate any cognizable case for which the FIR is lodged. At the stage of investigation, there is no question of interference under section 482 of the Criminal Procedure Code on the ground that the investigating officer has no jurisdiction. After investigation over, if the investigating officer arrives at the conclusion that the cause of action for lodging the FIR has not arisen within his territorial jurisdiction, then he is required to submit a report accordingly under section 170 of the Criminal Procedure Code and to forward the case to the magistrate empowered to take cognizance of the offence. This should be clear from the following discussion, etc. Now, kindly have a look at section 154. Registration of FIR is not investigation, my lords. Even direct. My lords are having 154
of the BNSS, Mr.
No, the old CRPC.
Old one.
Which is the new BNSS?
Old one. There are quite a few markings.
Give me the new BNSS. Because that time when the FIR was registered, the old
154, yes, FIR registration. That much I also know.
Information in cognizable cases. Every information relating to commission of cognizable offence given orally to an officer in charge of a police station shall be reduced to writing by him or under his directions and be read out to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book and kept by such officer in such form as the state government may prescribe in this behalf. And we are not concerned with this procedure. Now come to 156 and 157, my lords. 155 deals with non-cognizable causes with which we are not concerned. Any police officer in charge of police may, without the order of magistrate, investigate any cognizable case with the court having jurisdiction over the local area within the limits of such station would have the power to inquire into or try under the provisions of the chapter 13. No proceedings of a police officer in such a case shall at any stage be called in question on the ground that the case was one which such officer was not competent under the section to investigate. They was not competent, can't be called into question. Now kindly come to 156.3, magistrate can also order any. Now kindly come to 157.
Yes.
If from information received or otherwise, information received is 154, my lords, FIR.
Right.
An officer in charge of police station has reason to suspect the commission of offence which is empowered under section 156 to investigate. He shall forthwith send a report of the same to the magistrate empowered to take cognizance of such an offence. This has been sent to the Orissa court. And then he should commence with the investigation. So registration of an FIR is different from investigation, the point that I'm trying to drive at. Now kindly have a look at Lalita Kumari, where they said you have, if it is mandatory, you have to register an FIR, otherwise it's dereliction of duty. 180, which is that paragraph. Constitutional
Page 221.
Page 221. Come to that paragraph. Whether we can do.
Come to 27.
Kindly come to conclusions at para 120. It's a constitutional bench judgment of 5 judges, my lords.
Yes.
In view of the efforts and discussions we hold, that the registration of FIR is mandatory under section 154 of the code if information discloses commission of a cognizable offence and no preliminary inquiry is permissible in such a situation. So 5 judges of Supreme Court said if it discloses, you have to register, you have to jolly well register the FIR. It's another matter whether you have jurisdiction or not is another matter. Their entire thrust is. I'm sorry. Here also.
No, it's all right. Whichever camera. Yes. You can just carry on. Yes.
Their entire thrust is because of violation of section 6, the FIR doesn't have to go at the most, the investigation can go FIR subsists. Now kindly have a look at section 6 of the Delhi Special Police Act.
Yes.
First, kindly have a look at section 5. Extensions of powers and jurisdiction of special police establishment to other areas.
Yes.
the central government may by order extend to any area, including area, the state not being in the powers and jurisdiction members of Delhi Special Police for the investigation of any offences. So you are entitled, the power is for investigation. The registration of FIR is different from investigation. Point which I'm making, my lords. You may register the FIR, then you may find that there is no consent. It has to be sent somewhere. That doesn't vitiate the FIR. It may vitiate the investigation. But if investigation is also not vitiated, I'll come to those judgments, my lord. So let us assume. Now kindly have a look at section 6.
Yes.
Nothing contained in section 5 shall be deemed to enable any member of the Delhi Special Police to exercise powers and duties in any area of the state without the consent of the government of that state. So meaning thereby powers of investigation.
So you say 6 is relatable to 5, which
Yes.
in turn speaks about investigation.
Investigation. There can't be, because if you say that you can't register an FIR, you will be violating the Supreme Court judgments and you will be liable for dereliction of duty.
Very well.
So therefore, accept their case as it is, that CBI did not have territorial jurisdiction because there was no permission under section 6. That doesn't whitewash the FIR, it only whitewashes the investigation. ED is not concerned with who investigates the predicate offense. ED is concerned with the fact whether there's a predicate offense or not, whether there's a scheduled offense or not. The scheduled offense. The moment an FIR, in fact, in Vijay Madalla, the Lordship of the Supreme Court, so even FIR is not necessary for recording in ECR and for investigation. I'll come to that. But in this case, there's an FIR. FIR has been sent to the Orissa court under 157 for investigation. Orissa court has jurisdiction. I'll point out from the evidence in the FIR that it has jurisdiction, but that will essentially be a matter of the other jurisdiction. But I can go to that jurisdiction and also point out that there are evidence, crisp evidence which make out a case as far as Orissa is concerned. It is settled in law.
Mr. Raju, sorry for disturbing. I'm not very conversant on this branch. I mean, please clarify. I require a clarification from you. How far ED is bound by this DPAC? I mean, the Delhi police.
It is not bound.
Does it come under the purview of the Act? I'm not sure.
No, it doesn't come under the purview. All that ED is required to see whether there's
CBI,
a
yes.
that's all.
CBI, yes. But ED.
ED not. ED has to see whether there's an offense.
Right.
That offense is there because CBI has registered.
All right.
That offense cannot be set. That FIR can't be set aside because Supreme Court says if a cognizable offense is made, it has to be jolly well registered. You may strike down the investigation, but you can't strike down the predicate offense.
Worst case scenario.
Now, kindly have a look at the PMLA Act, my lords, and Vijay Madanlal in this context. You'll have to read something which is not there in the statute.
Yes.
Now, kindly have a look at proceeds of crime, my lords. 2(1)(u) of the PMLA Act. My lords have got it?
Yes, got it. P1U, yes.
Process of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property where such property is taken or held outside India, then property equivalent in value held within the territory or abroad. It doesn't say like this, but the process of crime means any property derived or obtained directly or indirectly by a person as a result of criminal activity as reflected from the investigation made by the CBI. That's not the case. Even as reflected in the FIR, that's the end of the matter. My lords, have got it? It may be in a given case that the CBI may file a closure report saying no offense is made out. At that stage, we can have a look at it. But at this stage, FIR is sufficient for invoking the powers of the PMLA. In a given case, CBI may say out of the 5 accused, one offense is not committed by one, it is committed by other 4. Then also Supreme Court in Pauna Dilpur says the PMLA offense continues. So PMLA offense has nothing to do with the investigation or competence of investigation of an investigating agency. It is the existence of a predicate offense. Now look at the FIR. Is the predicate offense disclosed? What was the page of the FIR?
It's a separate file.
Yes.
We don't have a copy.
I don't have the copy, my lords, but I can. Where is the FIR?
The FIR.
Yes, my lord. Now, can't you have a look at the FIR, my lords?
Which is a page number.
I don't have the page because they have not given me the page.
Right.
We are not served.
You are also
We are not served.
for the CBI.
ED.
You are also for ED.
Now, my lords may have a look at the first page of the FIR.
Mr. Raju, let me have a copy of the FIR first. Let the petitioners point out first.
Yes, my lord. It's saying that they have filed a petition and not having the copy of the FIR. On that ground alone, the petition requires to go home.
My lord, if Mr. Raju doesn't read the correct paras of Lalita Kumari, he doesn't deserve a copy of the petition because he's normally very meticulous, but he's missed the relevant paras of Lalita Kumari, which show the DSP Act.
He's leaving something for you to argue.
Your turn will come. Your turn will come.
He's leaving something for you to argue on, Mr. Luthra.
Point.
Yes.
It's 201, sir. It's 201.
201. Got it.
201 of the paper book.
FIR.
Now, kindly have a look, my lords. 420 is a predicate offense. 477A is a predicate offense. 13.2 and 13.1D is a predicate offense. Therefore, FIR makes out a predicate offense. And there are, kindly have a look, my lords, place of occurrence. 5, my lords, place of occurrence.
Yes, Odisha.
Charge Sumuda unit of so-and-so limited Odisha, 2 other places, West Bengal, and 1 place, Andhra Pradesh. If there are more than 1 places, the law is well settled. Any court has jurisdiction, any police has jurisdiction. That's well settled. I need not take my lords to that.
No,
Now, my lords, we kindly have a look. There are public servants also involved. The public servants are necessarily bank employees who have given the loan. They are nationalized banks and central government undertakings. The Supreme Court has taken a view that if there are central government employees or central government undertaking employees, consent under sex is not required.
Page 364.
No?
364.
Kindly have a look at
Page 364.
360.
364.
364.
364 of the compilation?
Yes.
Right.
Essentially, these people are fraudsters. They have duped the banks of more than 6,000 crores. On hyper-technical ground, they should not be protected when I have made out an arguable case. Now, kindly have a look at which is the page.
364 at 375.
364 at page 375.
Yes.
Yes, kindly have a look, my lords.
Para 25.
Para 25.
Right.
Irrespective of the place of posting, the aforesaid factual position would go on to show that there were central government employees, central government undertaking employees, allegedly committed serious offence under the PC Act, which is a central act. Therefore, the question is in such circumstances merely because such employees work within the territory of a particular state to register the FIR by the CBI in connection with the commission of offence under the central act, whether consent of the state government concerned is required or not, the said question is no longer a legal conundrum in view of the decision so and so. So there are bank officials, Government of India undertakings. So therefore, the question on Section 6 now goes for a toss in view of this judgment.
Conclusion.
Then, my lords, may kindly have a look at the operative portion.
28 and 29.
28, 29. 28.
28,
in the contextual situation, it is also relevant to refer to the resolution so and so Ministry of Home Affairs, the Central Bureau of Investigation going by the said resolution. It provides the function of CBI in cases where public servants under the control of the central government are involved, either themselves or with the state government servants and or other person. Thus, upon the alleged, we find it difficult to accede to the contention of the first respondent in the caption appeals made in it to support and sustain the impugned judgment. In such circumstances, considering the questions from such different angles, we have the firm view that the impugned judgment whereunder subject FIRs and further proceeding with person thereof, where cost cannot be sustained. Similar case. So here there are public servants involved. So this is an additional ground I'm actually arguing the predicate case, my lords. I'm not arguing the ED case. I'm actually arguing the predicate case. Therefore, to show that there's no prima facie case, all these judgments were not cited, not shown to my lords when my lords passed the earlier interim order. Then the second contention is this. Huh? Yes, Manik Bhattacharya. Kindly have a look at Manik Bhattacharya's case. I think it was cited on an earlier occasion. 202. The 202.
Interim protection and predicate does not extend to PMLA.
Short judgment, my lords.
Yes, Manik Bhattacharya, right.
Say 4, 5, and 7.
Para 4, 5, and 7.
What was the argument? What was rejected? Shall I read 4?
We heard the above two applications on 18th October 22. Mr. Mukul Rothgi, learned senior counsel for the petitioner, argued that when the letter was under the protective cover of an order passed by this court, his arrest by the enforcement directorate was illegal, being in violation of that order of this court. So there was a protection under the predicate for the predicate offense. The contention was the ED could not have arrested in the ED offense, PMLA offense.
His submission has
Since ED declaring the arrest of petitioner illegal. Such arrest was made by the enforcement directorate on the basis of ECIR report number so and so. We heard the above two applications on 18th October 22. Mr. Mukul Rothgi, learned senior counsel for the petitioner, argued that the letter was under the protective cover of an order passed by this court. His arrest by the enforcement directorate was illegal, being in violation of the order of this court. His submission has been that that the protection granted by this court was in relation to a particular offense. And that the enforcement directorate had arrested him in relation to the same offense which was unwarranted. Then kindly come to para 7. We cannot hold that the arrest of the petitioner by the enforcement directorate as illegal, as the issue of money laundering as there being proceeds of crime has not surfaced before the single judge or the division bench of the High Court before us. However, it has been brought to our notice by Mr. Rothgi in course of hearing the question of interim order passed in the instant special leave petition that the petitioner had been cooperating with the investigation by the ED and the CPI, where were testing the legality of an arrest made by an agency otherwise empowered to take custody of a person against whom such agency considers general subsistence of prima facie evidence of money laundering. We do not think as a general protection order directed at another investigating agency could have insulated the petitioner from any course of action in another proceedings. So order passed in CBI matter, how can it give them blanket protection in PMLA proceedings?
That's why I asked you whether ED is connected with the DPSA Act. That is the reason.
Next, can they have a next line, Manoj?
Started by a different agency.
Again, considers substance of prima facie evidence of money laundering. We do not think a general protective order directed by another investigation could have insulated the petitioner from any coercive action in another proceeding started by a different agency, even if there are factual similarity vis-a-vis the allegations.
Next slide. Under
the PMLA, money laundering is an independent offense, and in the event there is any allegation of the ED having acted beyond jurisdiction or their act of arrest is not authorized by law, the petitioner would be entitled to apply before the appropriate court of law independently. But that question could not be examined, especially but arising from in which the question of money laundering were not involved. Directly on the point, you can't say because I got a protective umbrella in the predicate offense, ED can't arrest me. That cannot be, and that's not the case. And Supreme Court has put its foot down. Para 8 also. In the present special leave petitions, having regard of this scope and nature of the proceedings, we are not inclined to go into legality and question involving the provisions of 2002 Act in arresting the petitioner. We are also satisfied that the order restraining coercive action being taken against petitioner passed by us on 27 September 2022, which you have directed to continue, did not operate to prevent the ED from carrying on with their investigation into allegations of the 2002 Act.
Correct.
So that order of my lord's interim order could never have prevented it. We were not a party. Identical facts.
Mr. Raju, what would be the position if ultimately they are acquitted of the predicate offense?
If they're acquitted, then they're acquitted. And if everybody is acquitted,
Is
if one
there,
person is
yes.
yeah,
It has to
is clear.
obliterated. Then the predicate offenses has to be obliterated. Before
So
that,
totally,
once an
either by
FIR is
acquittal or by discharge, if
or by
everybody,
discharge,
but that
yes,
is not
whatever.
the case here. They are not
No,
saying, my lords,
not at all
they are
the
not
case.
saying no offense is made out. They are saying technically you can't investigate. That's for different
Yes.
from saying that no offense is made out.
Right. So any irregularity or illegality in the investigation even cannot prevent you from proceeding with the PMLA offense.
Illegality investigation of predicate offense has nothing to do with the PMLA.
Right.
It's a standalone offense. We go and we sink or we stand on the basis of our investigation. We can't sink on the basis of other investigation unless the entire thing goes. That's a different thing.
Mr. Raju, suppose there was no FIR on the predicate offense. Still could you have investigated?
Yes.
In your
Can't have a look
perception,
at
there
Vijay
is...
Madalla. Yes, we could have
Yes, on
investigated.
that.
Vijay Madalla, para 269 and 295.
290.
Show me that.
Page 24.
Page
24. 24.
269, my lords, para 269.
24.
Para page 24 of my compilation.
Page 24. Probably some other. 24 is the paragraph itself. Page 24.
Page 24, para 269 of Vijay Madalla.
Yes. Very. Oh, Vijay Madalla. Very well. Yes.
The judgment starts at page 1.
Yes, Vijay Madalla. Yes. Yes.
From the bare language of section 3 of the 2002 Act, it is amply clear that the offense of money laundering is an independent offense regarding the process or activity connected with the proceeds of crime which have been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offense. The process of activity can be in any form, be it one of concealment, possession, acquisition, or proceeds of crime, as much as projecting or untainted property or claiming it to be so. Thus, involvement in any one of those such processes or activity connected with the proceeds of crime would constitute an offense of money laundering. This offense otherwise has nothing to do with the criminal activity relating to a scheduled offense, except the proceeds of crime derived or obtained as a result of that crime. Now, kindly come to para 295. Where they say we can make 66 to application. 290. 295, no?
290. Page 31. 295 I've got, yes.
290. 290.
290.
290, I'm sorry, madam, 290.
That's all.
Page 31.
30. Yes, 290.
As a matter of fact, prior to the amendment of 2015, the first provision acted as an impediment for taking such urgent measures, even by the authorized officer who is no less than the rank of deputy collector. We must hasten to add that the nuance, the restriction must be kept in mind that to initiate prosecution. We hasten to add that nuance distinction must be kept in mind and that to initiate prosecution of the offense under Section 3 of the Act, registration of schedule is a prerequisite, but for initiating action of provisional attachment of Section 5, there need not be a pre-registered machinery provisions cannot be construed in a manner which would eventually frustrate the proceedings in the 2002 Act. Such dispensation alone can secure the proceeds of crime, including prevent and regulate commission of the offense of money laundering. The authorized officer. Therefore, as far as attachment of property is concerned, confiscation is concerned, we can do it even without an FIR. Including investigation. We can carry out investigation with respect to proceeds of crime for the purpose of attachment and for the purpose of confiscation. Which is the paragraph?
Mr. Raju, was Vijay Madanlal revisited subsequently by the Supreme Court?
No, there's a review pending, madam. There's a review pending.
That's pending, still pending. Yes.
List on August.
Huh? August. It is listed in August.
Very good. No difficulty.
If our case is only on 2 points.
Page 116.
Yes.
80. Confusion 467 80.
Kindly have a look at page 116.
116. 116.
116 of the compilation.
18A.
18A.
116, yes.
18A, my lord. The paragraph starts like this. Conclusion, my 467 part of conclusions of para 467. And 8.
467.
28 8. Which is one? Which are you saying?
18.
18A has got.
18A.
Yes.
In view of the special mechanism envisaged in the 2002 code, ECR cannot be equated with an FIR under the 1970 code. ECR is an internal document of the AD, and the fact that FIR in respect of schedule offense has not been recorded does not come in the way of the authorities referred to in section 48 to commence inquiry investigation for initiating civil action of provisional attachment or property being proceeds of crime.
Yes.
So whether the FIR is registered or not is immaterial. As far as attachment confiscation is concerned, ED has jurisdiction. But in this case, the FIR has been registered.
Yes.
Maybe the CBI doesn't have jurisdiction, the matter to be tested. But today there's an FIR. Unless that FIR is quashed and unless the investigation is quashed, you cannot say that the investigation is bad at this stage.
44 explanation 1. 44 explanation 1.
Now kindly have a look at section 44, explanation 1.
PML.
Yes.
Explanation, my lords. My lords have got it after D, small d.
Got it, Mr. Raju.
For removal of doubts, it is clarified that the jurisdiction of the special court while dealing with the offense under the Act during investigation, inquiry, or trial under the Act shall not be dependent upon orders passed in respect of scheduled offense, and the trial of both those set of offenses by the same court shall not be concluded as a joint trial. So separate orders can be passed. That is not binding on the PMLA court. So PMLA is a standalone offense, different. Ultimately, the issue is whether CBI has jurisdiction in view of the absence of consent under section 6. The CBI's case is consent is not required because the offense is overlapped. There are several facets to the offense. Orissa, if there is an offense in Andhra, there is an offense. Therefore, it is not necessary that there should be that it is not an offense which is exclusively committed in Calcutta. If my lord wants me to take to the relevant provisions of the FIR, I can point out.
No, there are elements of Odisha also. Odisha
Yes.
and other states.
And there's misrepresentation, stocks, etc. May only point out clear case of cheating and clear case of criminal breach of trust as far as Odisha is concerned. Kindly come to para 6 and 7 of the FIR.
This is our factual notice.
Factual, not factual. I'm sorry, not factual. Have you given the picture? Therefore, this requires an elaborate hearing. Let my lords fix it for hearing. We'll argue in detail, my lord. I don't have the papers. I don't know what is their case.
Yes, CBI, you want to add anything?
My lord, I am not representing CBI. CBI is not even a party.
Yeah,
Only
well,
it is.
it is against it.
CBI is a party.
There are 1 or 2 more points that I want to address, my lords.
Yes, yes. Mr. All of you, Mr. Raju, Mr. Agarwal, and whoever is there, we'll have to fix it for final hearing on some other day next week. Not next week, this week, in fact. So tomorrow, can you come prepared? We'll just conclude arguments and I'll reserve the judgment and pass it.
Tomorrow, I have a problem because I have the Associated General Limited where Sonia Gandhi and Rahul Gandhi are active. I have to go.
I do have one submission to make for your lordship's consideration.
Yes.
Everything that we have heard, eloquence regarding whether the stay order granted by your lordships was correctly granted or not, and how Vijay Madanlal Chaudhary with reference to proposition of stay of predicate offence with others. We'll point out other paragraphs of Vijay Madanlal. On the issue of 223, on the pre-cognizance hearing, on the not a single word, Mulad, in my humble submission.
I have not completed my argument. I have not completed my argument.
Sir, let us have this clear. I mean, this is where, for all practical purposes, there is no scope of affidavits as such because all the documents are annexed. So we are practically hearing it on merits, the main application. Mr. Raju and Mr. Luthra and Mr. Agarwal, if you please conclude arguments by tomorrow, I mean, at any point. And Mr. Raju,
may I request for 22nd, not tomorrow. I have the Rahul Gandhi, Sonia Gandhi matter where I am to go, Mulad.
So when is it?
Tomorrow I am required in that matter.
22nd.
22nd. One day, only one day later, Mulad. Today is 20. AJL
is on 21st.
Mr. Raju, you are too much.
Yes, it can be tomorrow. AJL is on 21st. AJL is on 21st. I'll address my lords on 20th.
So we'll come back tomorrow then.
At 2 o'clock, my lords, 2 o'clock.
2 o'clock will be fine. Then I will.
Then let them serve a copy, my lord. Let them serve a copy.
Yes, yes, I will direct. I'll direct them to serve a copy. And Mr. Luthra and Mr. Agarwal, please come back with your replies after Mr. Raju concludes tomorrow.
Can I
Yes.
Someone else is trying to.
Can I just take one moment, my lord?
Can't see you.
My
Can't.
lord, my lord, Mr. Raju, just.
I mean, with due respect, who are you? I can't see you.
Zoeb,
I have been assisted by Mr. Zoeb Hussain, my lords.
No, he's there. Mr. Hussain, we have been hearing Mr. Hussain along with you.
And Mr. Samrat Goswami also, my lords.
I don't know, someone else probably wants to say something.
Samrat Goswami. I have been assisted by Zoeb Hussain and Samrat Goswami, my lord.
Mr. Luthra,
Can I just take a moment, sir? Can I just say one thing, Lord? Can I just say one thing?
Yes.
Lord, tomorrow I have a personal situation, Lord, which will save me from being in court. But no problem, Mr. Agarwal will go on. Can I just take 30 seconds to point out one thing? Just 30 seconds and point out one legal, Lord.
Yes.
And leave it at that. I will see tomorrow. It may not be possible for me to be present, Lord, even virtually. Mr. Agarwal is there, Lord. I just want your lordship to keep one thing in mind.
Yes.
And on the first part with Mr. tomorrow, Mr. Raju's argument is that the FIR cannot be done away with and he relies on Lalita Kumari. What he does not place before you is Paras.
No, I'm saying, Siddharth, if you have a difficulty, I don't mind if the matter is kept on 22nd to accommodate.
No, sir. Mr. Agarwal will go on. No, Mr. Agarwal will go on, sir. So you know my difficulty tomorrow.
I know that, therefore I'm not.
22nd, Mr. Raju, the difficulty is our court is closing on 23rd. So it will be difficult for me to pass the order within a day.
Sir, I will just conclude with one sentence. Mr. Agarwal and others are there. They're very competent to take over. Lord, I'll just leave your lordship two things.
Yes, Mr. Rudra.
Kindly just read para 89, 90, 91 and 92 of the Lalita Kumari. Lalita Kumari in itself, Lord, draws a distinction, and the language in 92 is in view of the specific point in the code, the power of CBI under DSP Act cannot be equated with the provisions of regular state police under the code. And all I want to say, Lord, is even the Constitution bench decision of 2010, which we'll send to tender to your lordships, the DSP Act is sacrosanct for the CBI.
The voice was gone. May I just indicate to your lordship that
Connectivity is an issue, big issue. It's coming in a fractal fashion.
Cannot pop it unless there are consents by the state. They don't have the power, and that is the distinction. It cannot of its own. It can act in union territory. All I'm saying is not. Can your lordship hear me better now? Can your lordship hear me now?
Yes, it's better.
Lord is better. All I'm saying is not. If your lordship looks at paras 89 to 92.
89 to 90.
Lalita Kumari, that settles the issue. The DSP Act is a distinct issue, and CRPC provisions, the exception, and 4 and 5 of CRPC say the exception is made out under DSP Act. Secondly, Lord, I will just point out that not only that, what is more crucial for us to remember is that in the 2010 Constitution Bench decision, the law is clear. The law is clear, and the law is that DSP Act is sacrosanct. The only way it can be overridden, that is to say CBI in a jurisdiction where it is otherwise not empowered, can only be done if...
Well, there are other judgments which take the contrary view. I'll point out when my turn comes.
It's clarified.
Lalita Kumari has been clarified.
We can actually see Mr. Luthra, Mr. Raju in your screen, but not on our screen. Therefore, whoever is in charge or at your end, at Mr. Raju's end of the camera, he or she is doing an excellent job because he's covering Mr. Luthra when we could see him on your screen. So thank you very much for that. But Mr. Agarwal, please take a cue from Mr. Luthra and continue from where he ended. Even if he's not there tomorrow, we'll keep it tomorrow at 2. Otherwise, I won't get the time to pass my order.
I appreciate it.
I appreciate. So Mr. Raju will continue with you for some time, and you will complete your arguments, and then here
at 2 o'clock, tomorrow 2 o'clock.
2 o'clock tomorrow.
Grateful,
Yes, sir.
One minute.
Just
if your lordship allows me a minute.
subject to what Mr. Siddharth Agarwal says, my lord, they have relied on a bunch of judgments. And I believe they want to argue more. My lord, let them complete. My lord, we'll argue on the next date. Kindly, my lord, because we will not be able to rely. We also need to rely upon many judgments, my lord. They have raised judgments. They are referring to, my lord, Vijay Madan Lal Chaudhary. In Vijay Madan Lal Chaudhary itself, we get exonerated. My lord, we want to show all these things.
Whatever arguments we made for admission only, my lord, it's not.
This is not final, and most importantly, my lord, greatest respect. ED comes up always.
So very
with
well,
an
then I
opposition.
can just if you say that, then if you don't insist on interim orders, then I'll just
No, the issue of interim order, let it be kept open, because the way Mr. Raju is arguing.
Interim order, the difficulty, interim order, if you grant, that would be granting you the main relief here.
No, I'm
Not necessarily, not necessarily.
Let us
May
take
I
a chance,
just
Mr.
point
Banerjee.
out
Let us
why
come back
now?
tomorrow at 2 if you want. If you can conclude arguments, I mean, we argue in a nutshell. What's the difficulty?
For interim orders only.
We need to. My lord, if they are not pressing for interim order, then
It's not a case of that.
No.
It's just a case where Mr. Raju has given a bunch of judgments. But
Yes.
Mr. Luthra as well as Mr. Agarwal needs to see
You've
these
not
judgments.
given us
They need to
file.
come up with fresh
They know
judgments.
90% of these judgments, if not 100.
Only
I
Mr. Banerjee, I'm sure they'll be able to reply on these judgments, Mr. Luthra as well as
only
Mr. Agarwal.
difficulty, your lordship will take us
My lord,
service. My
just
lord,
one
we need to
thing.
rely on few judgments also. If we do in reply,
they have also given us 17 judgments, my lord.
Then I'll
We are
take it
ready
after the vacation. No difficulty on my part.
No,
No, no, Lord, no,
Yes,
Lord,
Mr.
may I
Luthra.
just say this? May I just say this? Have it tomorrow. No difficulty, Mr. Raju. The others will hear Mr. Raju, not a problem. And all I was trying to point out to your lordship, not before I got disconnected and ousted, not
Yes.
on both devices somehow. I think
Yes.
Delhi claims to have power, but it really doesn't have the power that it should have. But not the point
That
I
was
was
a good
saying
one.
was
Yes. Yes.
that, yes, Lord, I am grateful, Lord. The 2010 3 SCC 571 says the only and only time the CBI can register FIR holds the DSP Act. Zohair, please mute for a moment. Is only when the High Court or the Supreme Court under 226 or 32 gives direction to CBI.
Exactly what I wanted to avoid.
Otherwise, CBI cannot act. And that constitution bench decision not to. So my learned friend's argument that they can register, I would say, Lord, untenable, because cannot act beyond a union territory. To be in a state, it has to have the consent of the state. That is what your lordship dealt with in your earlier order, and they have chosen not to challenge it.
No,
So
Mr.
today
Luthra, their challenge is not confined to the scope of my order, the previous order. They are
Yes.
on a wider footing also, on independent other grounds.
The wider footing that they raise is answered in para 109 and 382.8 of Vijay Madan Lal. Please see it. If Vijay Madan Lal says if a proceeding is quashed, or there is discharge, or there is acquittal, there can be no question of there being a PMLA proceeding. If the scheduled offense goes today, my argument is your lordship believes, your lordship has taken a view, I should say, that the jurisdictional offense, the jurisdiction to register an offense and to investigate both does not exist with the CBI. If that be the case, there is no scheduled offense. If there is no scheduled offense or predicate offense, the CBI, the ED cannot assume jurisdiction. That's the point. It's a matter of law, and I'll give your lordship the judgments in Ashok Corona and Ashok Kumar versus Unit of India Lord, all of which say the foundational fact needs to exist.
Yes.
Without the foundational fact, nothing is there.
Mr. Luthra, if you can please just indicate to Mr. Raju's junior the
I'll give the
judgments which you will be relying on, so that he can
My lord,
comprehensively
I
argue
will
on
tell
those.
your lordship not straight away. It's 2007 8 SCC 589. I will supply a copy to Mr. Raju as well. He and I have shared this
Do that
judgment
so that
many a
Mr.
time.
Raju in his arguments can cover those also, so that you can, in reply, you and Mr. Agarwal can come up
my
with.
lord. I will give those judgments, and Mr. Agarwal Lord will do a more able job than if I'm missing tomorrow. He's there, Lord. As we have a common first name, so I'm sure he'll honor the first name better than I do.
Yes,
Grateful.
yes, true. So tomorrow at 2 p.m. I'm keeping it. Mr. Raju, please make it convenient to come at 2 tomorrow.
Yes,
Sure.
madam.
We'll also be arguing.
I'll give the judgments to
Independent
Mr.
from,
Raju.
you are not
and
led by
send them
Mr.
across.
Luthra.
I am on one. And
Well,
I
I'm
have
in the
sub-
first one, he's in the second one. But there may be one practical difficulty. Your lordship will not take me amiss. Well,
All
all
the
of us
petition.
are.
The court is just hurrying up because you
Well, we do
urgency.
understand. I just tell you,
Because
lordship.
there is very little
Well,
scope
just give
of
me
granting
10
interim
Well,
relief
just
here.
give me 10 seconds.
I'm
Well,
making it very clear.
well, just I'm not pressing for that. Just give me
You
10
want a
seconds.
detailed hearing, court is ready to do that, but then we'll have to
Well, I
take it
just tell
after
you,
the
well, there's a
evidence.
practical difficulty. Give me 10 seconds. Well, we are relying on one of the points is 223 proviso breach. Now, the judgment has been pronounced by the Honorable Supreme Court of India, not being uploaded as yet. So,
So
whatever.
we cannot wait for that, sorry.
But it's pronounced judgment, my lord. It was pronounced on last Friday. I mean, not this Friday, it was
Cannot
the
look
last
into it.
Friday.
Let's
In
continue
any case, we
tomorrow.
have to rely on that, my lord. We'll
Let
rely
us come back
clearly there.
tomorrow, let us see if it is uploaded or not.
Very
But
well. And
tomorrow
we will,
is the
my
An
lord,
better-
we'll
order being
also,
better day
uploaded
for
to
us.
install them at a
very well, my lord. And we'll
Tomorrow
also
will be
rely on
better
few
day for us.
judgments, my lord. We'll
Your
try to give
lordships may have it, your lordships may have it tomorrow. We will assist the court.
tomorrow at 2. Very well. Yes.
Your lordships
But-
may then decide whether it is a final hearing or what the future
Yes,
course.
Mr. Agarwal, come
That's
have
right.
we'll have a consensus on that, and
That's
I'll
right.
hear it in any event either way.
I am most obliged, but we'll be here to
Raju
assist.
completes tomorrow. I may just seek an accommodation for Wednesday if tomorrow Mr. Raju takes some time. That's the only thing.
Very well. Very well. Hard in part for further hearing tomorrow at 2 p.m.
Grateful.
Well,
All four matters, all four matters.
All four matters together.
And they will give us copies, Manu.
Right.
Yeah.
Yeah.
I may just need some time day after.
At a line
That's
add
all.
further.
Others can-
Copies of all the applications shall be served on the respective appearing counsel for the
Well, we're just serving in court only, right?
for the
It will be my lord's pleasure to
copies of all the applications are being served on the learned advocates appearing for the enforcement directorate. Why leave out the de facto complainant? Give me a copy of it.
Concept.
Very.
Will it be my lord's pleasure to call the CBI also because the predicate of
No. I don't have a. In any event, calling CBI is never a pleasure.
That's as my lord's officer will not I pointed.
We'll come back at 2 p.m. Thank you so much. Thank you.
I am obliged.
একটু সাবধানে রেখে দিতে হবে এই যে অ্যাক্ট গুলো ওনারা দিয়েছেন ওনাদের ফেরত দিয়ে লাইব্রেরি ওদের বইগুলোতে
The print is going to be the same.
there is no assurance nowadays.
Okay.
Depending on the publisher.
Grateful.
Yes, sorry. Thought it would take 2 minutes, but entirely misread the. Anyway, yes.
Lord, this is the first appeal, my lord. I was the plaintiff, my lord. Suit was for specific performance and confirmation of possession.
This is appearing for the first time, this application.
Yes, first time.
Right.
The suit was for a specific performance and
Your suit or their suit? Your suit.
my suit. Yes. Suit for a specific performance and confirmation of possession. I was tenant in the property. My husband is the recorded tenant who negotiated with the owner, sole defendant, who stays in Sharjah. Now, my lord, in 2013, some negotiation was happened, and in the record, the defendant contention is that the plaintiff contention is that the property was proposed to be sold at 10 lakhs 25,000 rupees and odds, and 1 lakh and odd was paid as a part consideration. Now, the defendant taken a plea in the written statement. No, it was not 10 lakh 25,000, it was 25 lakhs rupees. So this was the disputes. Ultimately, the trial court held that the wife of the recorded tenant, who was the plaintiff in the suit, being a nominee, does not have any cause of action. Though the record says otherwise, there is a communications between my husband and the son. Even in the written statement, the defendant had accepted the proposal for sale of the property. These are part of record, my lord. My lord, at the initial stage of the suit, injunction was ad interim order was passed in my favor. Thereafter, that interim order
What was held by the court regarding possession?
Possession is with me. Possession is with me. In fact,
suit was dismissed. Why? Because you are a nominee, you are not entitled.
Yes,
you don't have
yes, yes. The learned trial
nominee
court-
in the sense, nominee in that agreement.
This was a oral because she was all the correspondences happened through email and telephonic conversation was there.
No, court says that the agreement did
No,
not.
there is no formal agreement. There is no formal agreement, but the contention is different. All the documents.
The court disbelieved the agreement itself, that there was no oral agreement. That
no
was...
oral agreement. Court disbelieved that. In fact, the written statement, my lord, if your lordship considers 2 paragraphs of the defendant's
What do they
statement,
say generally?
it says that she in fact visited at the registry office to execute the registered deed, but because of the amount
You are enjoying an injunction throughout the suit.
Yes, throughout till dismissal.
Sub copies will grant ad interim at this stage. Sub copies of the application will grant ad interim.
Yes, my lord. Yes, my lord. Yes.
We thought you were going to oppose that for a second.
No, my lord.
A prima facie case for hearing of the appeal on merits has been made out. Full stop. Accordingly, full stop. Moreover, it transpires that the plaint case of specific performance on the basis of an oral agreement has, in a roundabout manner, been adverted to with approval in the written statement. To some extent. Full stop. Next para. To some extent, repeat hoye gele dwitiyota deben. Next para. Moreover, learned counsel for the appellant submits that the appellant was enjoying an order of injunction during pendency of the suit. Full stop. In such view of the matter, the petitioner shall serve a copy of the application bearing Can 1 of 2025 on the respondent, indicating that the application shall be listed for hearing in the monthly list of June 2025. Push up, an affidavit of service to that effect shall be filed on the returnable date by the appellant. There shall be the respondent and stroke or her main and agent shall remain restrained by an order of injunction from dealing with alienating, transferring, and or creating any third party interest in respect of the suit property, and stroke or disturb the possession of the petitioner in respect thereof till disposal of the application.
Grateful. Grateful.
Lord, I appear for the respondent in this matter. So appearing for the first time after service. Lord,
The service has been completed, Miller.
On all the respondents.
Yes, yes.
My lord, I appear for respondent numbers 1 to 4.
Yeah, 1 to 4 has been served because we want injunction on 1 to 4 only.
Sir.
Yes.
You are the defendant in the suit or something?
No, I'm
Defendant numbers 1 to 4 in the suit, my lord, and respondent numbers 1 to 4 before your
So
lord.
they had contested only in the trial court.
Yes, my lord, they are the plaintiffs.
Yes.
Relief is against them.
Yes, relief injunction is against them, my lord.
Well, yes. So, what is the matter about the appeal arises out of?
My lord, there is an ad interim order was refused, my lord. So the order was passed, my lord, last August. On 23rd April, the order was passed, my lord.
Lord, if I may indicate, my lord.
Two things. One, we are putting the question to you because you took a prima facie case in view in their favor. One is that trial court held that there is a prima facie case, and secondly that they have a prima facie case in the sense that your title deeds were apparently subsequent to their gift deeds.
Not their gift deeds. The gift deeds of their vendors. My lord, my sale deeds are dated 2008. Their sale deeds are dated 2021. My lord, both registered sale deeds. Now, my
But
lord,
even their vendors, if they purchase the property prior to your deeds,
I have purchased prior to them, my lord. The parties before your lordships. My lord, the plaintiffs.
You have purchased from their vendors only, or
No, different vendors. My lord, I'll tell your lordship where the difficulty is arisen. My lord, the first owner of the land is one Amarendranath Bose. No dispute, undisputed fact. Now, my lord, our sale deeds say that Amarendranath Bose has one son, A. Their deeds say Amarendranath Bose has two sons, B and C. Now, my lord, who is the son, my lord? That's where the confusion is arising.
not A and B.
Not A and B. They are saying B and C are the only two sons. My deeds say, my lord, that only A is the son.
A is a
Is
different
the
person
only
from
son.
B and C.
And my lord, the sons are not the vendors. The properties have been transferred by virtue of various deeds and all of that.
By Amarendra at the first instance. Transferred.
Amarendranath Bose, the first owner, no dispute. Both
No,
parties are admitting.
The first
kindly
degree of transfers were by Amarendranath himself.
My lord, it doesn't say who
Yes,
held
this
the
is
land before
kindly
Amarendranath Bose.
list of that I'm giving last August. Not
But
list of
first owner, my lord, in terms of the averments made, my lord, in terms of our deeds also, is Amarendranath Bose.
So
My
their
lord, it
title-
does not say who held the property prior to him, but both parties, my lord, are ad idem that Amarendranath Bose was the first owner.
Yes.
My lord, I'll come to that. But today, my lord, I shall file my opposition, but without prejudice to my rights, my lord. I'm praying for a short modification. If your lordship may kindly take page 30. My lord, on the basis of the pleadings, my lord. My lord, page 30, volume 1, my lord.
You intend to file an opposition? Why?
Yes, my lord. One short modification, my lord. I'll tell your lordships why. My lord, page 30 discloses two schedules. Schedule A, they own 18.36 acres as per their deed. Schedule B, my lord, 86.90 acres, which is the entire property. Now, my lord, in terms of my deeds, I own the entire property. They say they own only 18.36 acres out of that 86.9. Now, my lord, today an order of injunction has been passed on the entire property, my lord, which they admittedly do not have a right.
An undemarcated property, then how can you
My
distinguish?
lord, if your lordships kindly take, my lord, they've mentioned the boundaries and all of that. My lord, page 30, schedule A. My lord, without prejudice to my rights,
An injunction which has been granted is only in respect of the suit property.
the entire property which they do not own even as per their own readings. My lord, entire property is 86.90 acres.
See the release shot in the plate.
Yes, my lord. Your lordships will kindly see the prayer, my lord.
Yes.
My lord, page 28 is the prayer in can 1.
No, not that. Yes, page 28. This is an injunction. This is an injunction.
Page 28.
My lord, prayers of the plaintiff are set out at page 16. The lordships will kindly see, my lord.
Let us see that.
My lord, your lordships will find prayer A. I'm sorry, my lord.
Prayer A, yes.
Prayer A, my lord, they are seeking declaration that they are owners of the property marked as Schedule A.
A and B are regarding Schedule A.
A is a part of B. But they are only seeking declaration with regard to A, my lord, which is
If A and B are regarding Schedule A.
yes, my lord. And the injunction, if your lordships find, my lord, page 17, para F. Page 17, para F. Permanent injunction restraining the defendants and their men, agents, and servants from using, occupying, enjoying, or in any way encumbering or dealing with the suit property, which particularly is described in the Schedule P.
B is the larger plot.
Yes, my lord. As per my deeds, I own the entire property. As per their deed, they only own 18.36 acres out of the entire property. So without prejudice, my lord may kindly modify on the basis of the averments made by them. That let there be an injunction on A and not B, my lord. That's all that I'm seeking today, my lord. Without prejudice to my rights.
Yes, how do you explain this? Because you have sought for a declaration of your title regarding A only, and that they have no right regarding A only. But how do you seek injunction on the entire B property? That you have to explain. Their right in respect of Schedule A is also disputed by you.
Yes, disputed by me.
Because your gift deeds also cover those.
My deeds cover the entire plot, my lord. Entire plot.
No, because they're challenging the gift deeds.
Yes.
So if the gift deeds
The
go,
deed has been challenged,
then
my lord.
entire B goes.
No, not by the gift deed. My lord, kindly see the list of their I filed last occasion.
So just explain this. You have asked, sought title regarding only A.
Because
Why?
I purchased this.
That in any event you have.
Yes.
But B, you have not claimed any right, because if they suppose their deeds are cancelled.
Is a deed. B is the entire deed, my lord.
If their deeds are cancelled, do you automatically become owner of B?
No.
Then how can you get an injunction regarding entire B? You can get an injunction regarding A. There's logic behind what your learned friend is saying. You are not heirs of Amorendra.
Yes, I purchased from the Amorendra.
Not heirs of Amorendra.
I'm not heirs of the
If you are heirs of Amorendra, then it would revert back to you maybe.
Yes, my lord. My lord, Amorendra has a two
You have
sons. My lord.
purchased Schedule A from Amorendra.
Yes, my lord, the entire property, what they are claiming from the Amorendra. My lord, we have purchased from the Amorendra.
You have not asked for title over entire B.
I have asking for the title what I purchased, my lord.
A.
Yes.
So how can you get injunction on B?
My lord, property is undivided, my lord. What is there? Purchase the entire properties.
Not demarcated. Let us see your.
No, not demarcated.
Come to page 30. Let us see that.
No, my lord.
You have given boundaries.
We have purchased this one, Schedule A.
Yes.
They purchased, there's no demarcation, my lord. In their deed.
No, if you have purchased with demarcation,
yes,
your title is restricted to A schedule property.
Correct, my lord.
Not B, the rest of B.
But rest of B is undemarcated.
Because it is the entire plot of land.
Where is my
It's
property?
undemarcated. The entire property either is undemarcated or some of it cannot be undemarcated.
My property is demarcated, my lord. I have a plan.
If your property is demarcated,
yes,
out of the entire thing,
yes.
Now that demarcated portion, then there is a demarcation. Why do you say undemarcated? The rest of the property within itself is not demarcated maybe, but it's demarcated from your property.
The question is, I have challenged the deed. The deed has been challenged, my lord.
The deeds, we understand.
Yes,
Just
deed
listen
has
to
been
us.
entered. Deed has been challenged.
Just listen to us.
Just, why,
you have to understand the logic first. Sorry, you cannot speak with us. You say you have purchased A, which is a demarcated portion out of entire B. You challenge gift deeds or transfer deeds in their favor, by virtue of which entire B schedule along with A schedule has been transferred to them. Today, if the deeds are cancelled, the gift deeds are cancelled. It's cancelled in its entirety. Then your title reverts back in respect of A. Because if those deeds are not there, your interest is restricted to A property. Because the cloud on A goes because the gift deeds are removed. But if their deeds are removed, then you get only title in respect of A. Still then, even if their deeds are not there, then also you don't have any right on the rest of the B schedule property. Do you? Because you have never purchased the rest of B schedule property apart from Schedule A. Do you get our point?
Understood, but if the injunction is
See,
listed,
this is Schedule A.
I understood.
The entire Schedule B.
Yes.
You have purchased only this part. Demarcated part, you have given the boundary. You have purchased only the upper part.
Yes, below.
Their deeds cover the entire book.
Yes, below.
If their deeds go, then B becomes relieved. The rest of B becomes relieved as well as your A. But your right remains restricted to A.
To my what I purchased, that is there.
Only that.
Yes.
So we can restrain them regarding A schedule property, regarding the rest. Even if you win the case, their deeds are set aside, cancelled, then also you don't have any right in the rest of B. So how can you claim an injunction to the rest of B?
Well, because of I understood, because
somebody else might.
Yes, by allege the deed, because there is in the deed below their deed, there is no demarcation, but it bounded anything.
That is what we are saying.
Yes,
they have got the entire property.
If injunction is restrain them on the basis of their deed below, if they sell the properties now, Milord,
we'll restrain them. We have already restrained them. We'll restrict the restraint order only to the A schedule property. They cannot transfer A schedule property. Even if they transfer, they'll have to transfer minus A schedule property.
My lord.
We'll not say minus, or the mathematics will skip over. But this will be. You can argue otherwise. I mean, if you have anything to say, you can say.
I have one more submission to
Yes,
make.
yes.
Now, my lord, with regard to the sons, my lord, the dispute, that's where the dispute is. Who are the sons of Amarendranath Bose? They say two other people, I say one other person. If your lordships may kindly direct an inquiry to that.
No, we are hearing an appeal only against an ad interim refusal, I suppose.
Yes.
If you agree, we can, with that rider, we can dispose of the appeal and leave all questions open for the trial court to decide in the injunction application itself. File your objection in the injunction application. If you decide everything, nothing will remain in the injunction application.
One point, my lord, why I want to file an opposition with your lordships is, my lord, the gift deeds are not on record, which they are heavily relying on.
No, we'll say that you are
on
not,
record.
you are denying all of these allegations made in the application. That will record in any event.
Yes.
You are denying, it's deemed that you are denying all the allegations. But if we go into that, the entire trial at this stage, then nothing will be left for the injunction court to decide. So we'll just modify our order to that effect, that only regarding A, the injunction is restricted to A. We'll direct the injunction application to be heard out within a limited period. You will file your objection to the injunction application with a limited period. And we'll make it very clear. This is for both of you. No, we are just looking at him, but for you also. And we'll make it very clear that these observations are tentative for the purpose of this ad interim stage, and it will not bind the court at any subsequent stage, including the injunction application hearing.
Well, one humble submission.
Yes. What is your...
my submission is Mr. Saptang Sowas, who is senior, is leading this matter, Milord. Kindly make it on 22nd.
That is not neither a question of law nor a question of fact.
Understood, Milord. But so far as the transfer of the remand of the matter is concerned, Milord, kindly on 22nd, can fix, Milord.
Not remand. We'll dispose of the appeal.
Yes,
it's in any event, the main injunction is pending.
Yes, there is pending.
We'll dispose of the appeal.
Okay.
My lord, in one submission, if, my lord, they may be directed to bring on record the gift deeds before the trial court.
My lord,
before I put in my objection.
Their gift deeds.
Their gift deeds.
We cannot compel them to produce any document.
My lord, they have heavily relied upon that.
They would have noticed, Milord. I have already served.
Yes, they've served, my lord. They've served upon me. Let that be brought on record.
In the suit. You know what to do in the suit. If they rely on particular documents in the plaint, there are at least three options for you. Including their plaint being rejected. If one of the options is not fulfilled.
Well, it's in Bengali. If English translation could be served upon us. Well, the only thing, 1960 document, well, not very legible. What I have been served with.
But if your accent is reflected in your reading of Bengali also, then you require a translation.
No.
Court may not need. So, no, have it translated in the trial.
Right.
The translations are less trustworthy than the original documents. Still better to have an half legible original than a translation. We are regularly getting translated copies, and like Google, I mean, calf muscle. There was a search on calf muscle. It came out bachurer tissue, something like that. Literally, this morning I found it. One of my friends showed me. So don't rely on that.
Right.
Mr. Basu is in the court proceedings.
No, Milord.
He's not in court.
Not in court. That's why
we'll keep it tomorrow. We'll keep it.
Not tomorrow. Tomorrow is not available. So, 22nd, Milord.
No, then we'll decide there.
Milord, tomorrow is, Milord, decided. 2 p.m. Milord, the big matter is fixed, Milord, tomorrow.
This is a small matter. This will be taken up before that.
Tomorrow is not available, Milord. Day after 22nd, Milord. Kindly. Just 2 days, Milord, in the meantime.
Then we'll keep it after the vacation and modify the.
My lord will kindly.
No, then we'll direct you to file a written objection. The entire thing comes up.
Then we'll better to direct the.
My lord will kindly modify, my lord, the schedule A and B.
Do that.
Yes.
Do that.
Grateful. I'll file my opposition.
heard learned counsel for the parties. Full stop. An adjournment is sought on behalf of the appellants on the ground of non-availability of the senior advocate, learned senior advocate, leading counsel for the appellants. Full stop. Next para, learned counsel appearing for the respondents opposes the prayer for injunction and contends, comma, inter alia, comma, that in any event, comma, the injunction could not have been sought for in respect of the entire B schedule property, comma, within which the Schedule A property is a part. Full stop. By taking the court through the reliefs sought in the plaint itself, comma, learned counsel for the year for respondent 1 to 4.
1 to 4.
যেখানে যেখানে respondents বলেছি 1 to 4 হবে. It is contended by learned counsel for the respondent numbers 1 to 4 that the plaintiffs themselves have sought a declaration of their title in respect of Schedule A property. Full stop. Merely because the plaint case also challenges the transfer deeds in favor of the respondent numbers 1 to 4, comma, which covered the entire B schedule property, comma, injunction ought not to have been granted in respect of the entire B schedule property. Full stop. Upon hearing learned counsel and on perusal of the nature of relief sought in the suit, comma, we find that there is substance in the content in the above contention of learned counsel for the respondent numbers 1 to 4. Full stop. Next para, the reliefs, comma, as sought in the plaint, comma, make it abundantly clear that insofar as the declaration of title of the plaintiff stroke appellants is concerned, comma, the relief small a within bracket and small b within bracket sought in the plaint restrict such claim of the plaintiffs only to the Schedule A property. Full stop. The decree for declaration that the plaintiffs are the owners of the Schedule A property and that the defendants have no right, title, and interest in respect of the said property make it clear that the plaintiffs, comma, in any event, comma, do not claim any title regarding the rest of the B schedule property. Full stop. Next para. Although learned counsel for the appellants contends that the transfer deeds in favor of the respondent numbers 1 to 4 do not reflect any demarcation, and as such, comma, the A schedule property might also be jeopardized in the event any transfer takes place at the behest of the respondent numbers 1 to 4 regarding the B schedule property, comma, we find that as per the description of the Schedule A property in the plaint itself, comma, the said property is a subset of the B schedule property and is clearly demarcated by boundaries as per the plaint description. Full stop. As such, comma, the larger B schedule property is demarcated between the portion covered by the A schedule property and the rest of the B schedule property. Full stop. Next para. Since in any event, comma, even if the plaintiffs succeed in their challenge against the transfer deeds in favor of the respondent numbers 1 to 4, ultimately in the suit, comma, the plaintiffs would not have any title in the rest of the B schedule property apart from the Schedule A property, comma, we are of the opinion that there is substance in the prayer of the respondent numbers 1 to 4 that the ad interim order granted earlier should be modified by restricting the same to the Schedule A property. Full stop. Next para. Accordingly, comma, we modify our order dated April 23, 2025 to the extent that the injunction granted therein, comma, restraining the respondents and or their men and agents from selling, comma, transferring, comma, alienating and stroke or creating any third party interest in respect of the suit property is modified to the extent that such injunction shall operate only in respect of the Schedule A property. Full stop. As recorded earlier, comma, the said injunction, comma, with regard to the Schedule A property now, comma, shall continue to the disposal of the injunction application. The respondent numbers 1 to 4, comma, being the only contesting respondents, comma, shall file their affidavit in opposition within
fortnight after vacations.
Within June 20, 2025, full stop, reply if any shall be filed within a week, within
2 weeks, my lord.
2 weeks. Within July 4, 2025, the application shall be listed next on July 8, 2025 for hearing.
Grateful.
Grateful.
My lord.
Millard 26, Millard, I appear for the appointment. Can I come back tomorrow, Millard? Mr. Chatterjee is leading me, Millard, due to some Millard emergency, Millard. He, at 2:30 has maybe.
Yes, what do you say?
My lord, I am for the respondent number 1 and 2, my lord.
You are for?
For the respondent number 3, your lordship.
Whatever you say, both of you.
My lord,
If you oppose, please oppose and I'll
no,
give.
on ground of Mr. Chatterjee, I will not say. Let it appear tomorrow.
Tomorrow come back.
Yes.
On the prayer of the appellant, let them attest and adjourn for the day.
Millard, I have filed the affidavit of service.
Affidavit of service filed today be kept on record. One of the নামগুলো record করে রাখবেন.
Grateful.
Please give your names, all of you. Yes.
My lord, I appear for respondent numbers 1 and 2.
Well, I bought a plaintiff appellant, my lord. This is the affidavit of service.
10 to 14, yes. You are for respondent numbers 1?
1 and 2, my lord.
1 and 2.
My lord, I am suffering an interim order, my lord.
You are suffering, yes.
My lord.
What is the
Plaintiffs are the appellants before your lordship, my lord. This appeal is directed, my lord, against an order of refusal of interim order of injunction. My lord, admittedly, my lord, the parties are the possessors of the property in question. My lord, what, my lord, the other possessors are doing, my lord, denying the title of the plaintiff, my lord, posing themselves, my lord, the sole owner of the property in question, my lord. They are trying to transfer the alienate the suit property by making multi-story building therein. My lord, we paid for, my lord, injunction restraining them from transferring the suit property as well as, my lord, for changing the nature and character of the suit property. The landed court below, my lord, by order impugn, my lord, was pleased to refuse the order of injunction, ad interim injunction on the ground that these two pleadings, my lord, one is, my lord, changing the nature and character, and also, my lord, the trying to transfer the suit property is contrary to each other. Only on that ground, my lord, the
yes, remember. Your choice. Either we extend the
I'm not on that.
interim order till disposal of
There
this
is a
appeal and keep it pending, or dispose of the
But
appeal
there
and
is a
directly.
different aspect altogether. My lord, the
Will directly injunction
application-
application to be heard out. There should be injunction.
My lord,
By the
this
trial court.
application has been filed, my lord, by totally suppressing a material fact. What? That there was a probate proceedings, there was a will. There was a will, my lord, which was executed by the grandfather of the petitioner and the opposite party numbers 1 and 2. Now, my lord, that was probated by this honorable court in 2006.
Yes.
In that probate proceedings, my lord, in that will, my lord, it was decided that the entire property will be bequeathed in favor of my clients, that is 1 and 2. That has been totally suppressed in the plaint. And
has been bequeathed.
Yes.
The probate has been granted.
Yes. That is why in 2006.
Then file your objection to this.
Yes,
Opposition.
I have to file, my lord. I have the documents with me. If your lordship kindly
Mr.
permits me, my lord.
So Haldar, now it has been held Calcutta
is
Club
why-
and other cases that
That is why, my lord, I have
appellate court
to
also we can look into that whether there is
kindly
process.
seize this.
No, need not see anything.
My lord, I have
Let
gone
him
through it.
see it so that you can.
And in respect of this property, that also I have checked up. In respect of this property,
Injunction is there till disposal of the injunction application. How soon can you file your opposition? As soon as you can. It depends
yes, my
on.
lord, I have to. My
You
lord,
are
because
for which of the respondent? 1 and 2.
1 and 2, my lord, in their favor, my lord, the will was probated. They were the beneficiaries. They were the only
We have
beneficiaries.
served on the others. We directed to serve only on the
only different number 1 to 3.
1 to 6.
1 to 3.
Because your injunction is against them only.
Yes, I paid for injunction only against them.
But this fact was also suppressed in the plaint. And on the very first day, they obtained an interim order. Order 39 rule 1 and 2 ex parte.
How soon can you file your opposition? Tell us.
Immediately after the vacation, well, because in 2 days I cannot file, my lord.
No, obviously not. We'll give you 1 week after the vacation.
And my lord, in the meantime, my lord.
Meantime, this will remain.
My lord, the difficulty is that, my lord.
But vacate our order. No. Without something on record, we can.
My the work is continuing, my lord. They have come up with this application by suppressing this fact. That is why, my lord, I have brought the documents. The probate
Bringing
documents,
the
the
documents
order.
won't do it. Those have to be affirmed on oath.
I understand, my lord. Everything has to be on
Learned
record.
counsel representing the respondents 1 and 2 submits that.
Well, can I continue, my lord, with the war? But I will not alienate.
Definitely not. No. You have been injuncted by a court of law. You can continue.
No.
But you will have to continue
your
your
lordship's
residence
order.
elsewhere then.
No.
Even my lord,
If your lordship modifies the order, then only. Otherwise, not. I have seen your lordship's
No,
order.
you won't continue with the order.
Even in the teeth of this order of injunction, my lord, they are making construction.
Teeth will be brushed
Yes.
soon. Teeth will be brushed soon when they bring out this.
Everything is on record, my lord. And the executor was their father only. So they cannot say that they don't know. It was in 2006, probated in 2006.
Learned counsel representing
Had
the.
they not suppressed this fact, my lord, lordship may not have passed this order.
True. Learned counsel representing the respondent 1, 2 submits that there has been gross suppression in the plaint as well as the injunction application in the court below as well as before this court in obtaining the ad interim injunction order granted by this court earlier. First off, it is submitted that the entire suit property has been bequeathed in favor of the respondent numbers 1 and 2
Yes.
by the predecessor interest stroke father of the parties by a will. Full stop. It is further submitted that the will has since been probated
By this honorable court, my lord, 12th of April 2006.
by this court on April 12, 2006, which
PLA
was
number, my lord,
within the knowledge of the appellant. Full stop. Next para. Since certain serious allegations have been brought by the respondent 1 and 2, comma, the respondents 1, 2, and 3 are directed to file their respective affidavits in opposition.
My lord, I am for 1 and 2 only.
Yes, but because they have been
Yes.
that's why respective affidavits in opposition, both of separately. Opposition within June 13, 2025. Full stop. Reply, if any, shall be filed within June 20, 2025. The application shall be listed for hearing on June 23, 2025.
Interim order, let it be continued.
That is there till the
No, my lord,
disposal.
no, not till disposal. It was granted, my lord.
The interim order granted earlier is extended till June 30, 2025 or until further order, whichever is early.
Yes.
Great.
Thank
Well, now.
Mr. Halder, take instruction.
My lord.
My lord, 13 June.
Your suit will go.
Affidavit of service file be kept to the record.
My lord, the suit.
Affidavit of service file to be kept on record.
My lord, suit, my lord, is. But the main suit, my lord, will go, my lord. If...
Incidentally, we will not do that.
No, I know.
It has been done in some cases by others.
Great.
Yes. But Mr. Kormakar's suit we cannot guarantee. Your suit or other side suit?
The plaintiff, Lord,
you are
on
the
last
plaintiff.
occasion, Lord, my lord is directed to serve. Lord, we have served. This appeal was formally admitted. Lord,
What about the service? They have received?
they have received. Order of remand, my lord?
Yes. Only one.
Only one.
So we'll extend it till disposal. What was the nature of the injunction, Mr. Kormakar? Just remind us.
Lord, kindly terms takes, Lord, 29th of April 2025 order, my lord.
Yes.
So, Lordship would kindly come to, Lord, page.
Ejectment suit. Achha.
Yes.
What about the, just
Para
remind
10.
us of the facts?
Lord, eviction suit. Eviction suit, Lord, remanded on the ground. Lord,
Your eviction suit.
My eviction suit.
Remanded on the
Lord,
ground?
remanded on the ground that I failed to prove, Lord, the reasonable requirement because no inspection was carried out. I said from the exhibit itself, Lord, it will be evident that it's a self-contained flat. How many rooms are there? It will be evident from the sale deed. So nothing more is required. Lord, para 10, Lord, your lordship had, Lord, of the judge order, Lord, last day's order.
Upon despite service, none appears for the respondent. Full stop. The affidavit of service filed today be kept on record. Full stop. We find that on April 29, 2025, comma, upon hearing learned counsel for the appellants, comma, and giving elaborate reasons, comma, we had granted an ad interim order of stay by molding the reliefs. Full stop. Next para. The present appeal has been preferred against a remand order whereby the plaintiffs, you had obtained a decree.
I had obtained a decree.
The plaintiffs suit for eviction on the ground of reasonable requirement, comma, which was decreed by the trial court, comma, was remanded merely on the ground that no local inspection was held to show the nature and extent of the alternative accommodation of the plaintiff stroke appellants. Full stop. However, comma, it is argued by the appellants that it will be evident from the title deed of the appellants as to the exact extent and measure of the alternative accommodation available to the plaintiffs stroke appellants. Full stop. Next para. Thus, comma, an arguable question has been raised as to whether the learned first appellate judge could have himself or herself, himself decided the appeal within the contemplation of Order 41 Rule 24 of the Code of Civil Procedure. Full stop. Since a prima facie case for hearing of the appeal on merits has already been made out, and the balance of convenience and inconvenience is in favor of grant of injunction, and unless such an injunction is granted, comma, there is scope of the appeal being rendered infructuous and the appellant suffering from irreparable injury, comma, we are of the opinion that the interim order granted earlier ought to be extended, made absolute. So accordingly, can one of 2023 is allowed, comma, thereby granting stay of all further proceedings in ejectment suit number 530 of 2011 pending before the learned judge, 5th bench, Presidency Small Causes Court at Calcutta, after remand till disposal of the appeal. Push up next para. The appellants shall put in postal costs and other requisites for service of notice of the appeal on the respondent within a week from within June 13, 2025. Push up. The trial court record shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within June 13, 2025. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Obliged.
Please, Your Lordship.
Yes.
Well, this is my appeal.
Yes, Mr. Medora, what is the appeal about?
Yes, well, there's a Section 5 application. On the last occasion, Your Lordships have been pleased to pass an order allowing us to, my lord, file a supplementary affidavit because, my lord, the grounds, my lord, made out in my Section 5 application were not very happy.
Socio-economic condition.
Also, yes.
No, that was written. That was your ground.
Remembers that.
No, we remember now, recollect now upon
That
seeing
was
it.
the last occasion also, Your Lordships.
Yes, that catches the eye actually.
Well, I have
attributably inter alia to socio-economic condition. What is the socio? What do? You are a big business magnate.
No. Far from that, my lord. The matter was filed by my late husband in 2019. And I'll hand over a copy of the supplementary affidavit, my lord, which has been prepared. That perhaps will explain the grounds.
You must have got a copy of it.
Yes, I've served
We dealt with that.
Dealt with that.
Yes.
We have not been given any copy of any opposition, though
We have also not been given any copy.
we were supposed to be given by 14th May. Till today, till this moment, I haven't got it. But I'll argue the matter, my lord, with or without that opposition, because I'm in some predicament.
I'm told that the client was not there, and she came today, and it was affirmed today.
Yes, please, Mr. Medora.
Yes, my lord. My lord will kindly take my supplementary affidavit.
Yes, supplementary affidavit. Yes.
Paragraphs.
What is the challenge against, Mr. Medora?
Well, the challenge, my lord, this is the second appeal, my lord. The suit was initially filed before, my lord, the trial court, my lord, for eviction. I was the defendant. Suit was dismissed.
Eviction on the ground,
non-payment of rent, default. Default of rent and default of municipal taxes. My lord, trial court, my lord, dismissed the suit. They went up in appeal. It was reversed. Now we are before your lordships. My lord, so far as the delay is concerned, my lord, I have tried to explain the same, my lord, in page 2, my lord, of my supplementary affidavit, paragraph 4 onwards, paragraphs 4 to 10, my lord.
It was originally against your husband.
Originally against my husband. Yes.
At what stage were you substituted?
Very recently, my lord. After he has passed away, after the appeal was filed. After this appeal was filed.
After this appeal was filed.
Because he passed away in 2023.
So the explanation has to be for your husband's.
Yes. So I was in a bit of a difficult position to explain the delay on the part of my husband, but I've tried to make out some sort of a case, my lord. And luckily, my lord, I have one document also, my lord, in support of what I've stated.
Yes, Mr. Gupta.
There is two other things which I'll indicate to your lordship before your lordship takes up this. But your lordship would correct me, your lordships, but possibly the substitution could not have been allowed in the appeal because there's a section 5 which was not filed. So there was no appeal in the eye of law. So possibly, subject to correction, there should have been leave to present an appeal by the wife.
That application has been allowed.
Application has been allowed.
We have allowed.
No, single bench.
Substitution.
Yes. But this is what is troubling me. I am unable to assist your lordship with the law on that, but because 3 applications already allowed. One is a substitution, one is a setting aside of abatement, one is a condonation of delay in filing the substitution.
We'll deem that to be an application for granting leave. And probably, Mr. Gupta, there is it may not be correct to say that it could not have been allowed before the section 5 was heard, non-est, because even in the section 5, it could not be in the name of a deceased person. Even the section 5 has to be moved by a living person. So it has to be done before that stage. When with the substitution all leave is granted, that leave percolates to the connected application.
I have advised my clients to take out a recalling application of that order.
We'll make that infractious ab initio.
Because without the section 5 being there on board at all, that was
no section 5.
Section 5. Section 5 filed recently in April 2025. That was allowed a year.
See the order. We'll constitute the order.
No, kindly not do that.
No. Right now.
Your lordship will kindly see the order once.
My attention to the paragraph. Explain the delay.
But if your lordship kindly takes a look at.
Yes. That substitution that
and
7th of February 2025 order will constitute as granting leave to prefer.
But at that point of time, there's no section 5 also on board. Nothing is on board.
Unless they have a leave to file an appeal, how can they prefer a section 5?
The leave to appeal is also not there.
This is that leave to appeal.
But
this substitution order granting substitution will constitute that to be the leave. That substitution which has been allowed will say by virtue of allowing the substitution application, what was intended by the learned single judge was to grant leave. We will constitute that.
But the prayers are something which is completely different.
These are very technical, Mr. Gupta. What substitution is allowed? That order has attained finality. Recall, there is very limited scope. We'll say that that was leave granted.
We were not represented at that point of time, but
they were served. More than once, possibly.
Not so.
So served twice, 2 applications allowed, right?
No, not
possibly twice, but I'll check. But definitely served.
What was troubling me, and I was trying to.
No, it's troubling us also. We'll remove the trouble. We'll iron out the trouble.
But
substitution has been granted by a competent court, by a learned single judge, Mr. Gupta. Yes, we can appreciate that you are not there, but you are served. So if substitution has been allowed, we cannot nullify that order. We'll say that there was no scope of substitution because the demise occurred after the filing, after the passing of the impugned judgment. So obviously,
after the filing of the appeal, after the everything,
after the filing of the appeal.
Yes.
Then substitution was the right. After the filing of this appeal, the death occurred before.
Your lordship will kindly, your lordship will kindly note 2 dates. The impugned decree in the appeal is dated 2019. The appeal is filed beyond the period of limitation in 2019. But beyond the period, there was a delay. No section 5 accompanied the appeal ever. The original appellant was alive till 2023. No section 5 filed. 2023, he passes away. 2024, 2025, these applications were allowed. Still no section 5 on board. For the first time, section 5 filed on 28 April 2025. This is what is troubling me. but I am unable to find any judgment to directly assist your lordship with that. So that is why, my lord, I was saying that since no appeal was on board because there's a delay and a section 5 was not on board at all, could the substitution have been carried out? It's a question which I put to myself, but I really don't have an answer. So, my lord, I leave that to your lordship. That is the only thing which is, my lord, trouble.
We are not sitting in judgment over that.
But I understand. But section 5 also, my lord, I should go strictly to the learned single judge. But I was, that is, since my clients were not there, so my lord, we had taken out, we shouldn't say we're taken out. We are in the process of filing an application for recalling of that. That is the whole difficulty of that order.
That recall application would be time barred after 30 days. No, Mr. Gupta, court has passed an order.
But
substitution,
possibly that order could not have been passed in the facts, because the appellant, the original appellant, was alive till 2023. There was no section 5 at all.
No,
so the appeal was not there.
The appeal was filed in the year 2019 itself.
Beyond the period of limitation. So technically there was no appeal. Under order 43, 3A possibly, it has to accompany with an application for condonation of delay. That is not there.
Application can be filed later.
That is the judgment. Has been treated as
several
yes. But good, bad, indifferent, that section 5 was never filed by the original appellant for good 4 years. Now the original appellant passes away in 2023. The substitution is carried out in 2025 without a section 5 being there on board at all. And why suddenly they are coming up is because we are going ahead in the execution. That is the only reason. So, in my humble understanding, and I completely will bow down to your whatever will fall from your lordship, because I have not been able to find anything either for or against to assist your lordship with that.
Now you will find after our order.
Hopefully for. Because
technical.
My only submission
is died, his wife is seeking to carry on with the appeal.
That is a sympathy.
Why shut them out?
That is a sympathy which possibly court cannot possibly hold in my favor for the only reason till 2023 the original appellant was alive. He could not do so suddenly. That default that latches on the part of the original appellant so that cannot be now.
That we will consider in the section 5. The section 5 is for that only. We will deal with your arguments and first constitute this.
Could I try and assist your lordship with one judgment on the point that a section 5 application filed long after the filing of the second appeal.
How long after 3 years?
This is after 6 years. So Article 137 would also possibly come into play. So I am backed by a judgment of a coordinate, not a coordinate, a single bench.
Even then,
in a section, in a second appeal, but since it was at the admission stage, so it's before the honorable single judgment. If your lordship kindly considers this.
Admission stage, since it was at the admission stage.
Yes, because section 5 was being considered. That is why, because section 5 is normally considered by a single bench. That is why. But your lordship this would possibly only have a persuasive.
Mr. Medora, I think we think this should be then sent to the learned single judge, because in all fairness, there is a substitution application. They are intending to file a recall application. So it's better that, but it's a different judge now. Yes. Recall, in any event, you don't get, the recall will be heard by someone else, and Justice Day still has jurisdiction.
Yes.
Has jurisdiction.
Yes. And it's Justice Day who had passed the order. So we'd be filing the recalling for the same judge, and the second appeal determination is also with Justice Day.
We'll keep on record and relegate it to the learned single judge.
It's a very technical argument, Malad. I appreciate his point, Malad.
No, but it should go before the learned.
Only one consideration, Malad. The execution, Malad, is at a very ripe stage. The matter is coming up day after tomorrow, Malad. Kindly give me some protection till the matter is considered. That is my only humble request today. On the last occasion, I requested Mr. Gupta.
For the first time in 2025.
Yes,
so
I admit that.
He's ousted, then what remains in the appeal? Yes. Or we'll hear. We are hearing.
Grateful, Malad.
Applications in connection with Order 41. Mr. Gupta, applications in connection with Order 41. We have determined.
But I'm not shying away from any court, but I was just only pointing.
What was held here? Do you have another copy? You give a copy to Mr. Medora also.
Yes, I've got a copy.
Yes.
And if your lordship kindly takes a look at the first paragraph.
Yes.
Second judge copy down.
আপনার এটা নিন
I'm sorry. I'm sorry.
preferred second appeal हो जाए
এটা কি two copy letter? But if your lordship kindly takes a look at the first paragraph, this is not paragraph number is not there. This is an application for condonation of delay in preferring the second appeal. The original appellant who filed the appeal and the present application has died, and his heirs and legal representatives have already been substituted in the appeal as the appellants. But identical facts.
a division bench judgment was cited there.
Yes, I'm carrying that also. I'm carrying that also. On and your lordship is already on the second. Yes.
Have you got a copy of the limitation? Limitation একটা আছে এখানে দিন না ল্যাঙ্গুয়েজটা দেখি
I have one copy, my lord. Okay.
লিমিটেশন একটা ওনার কাছে দিন এটা দেখতে ভালো
Better than mine.
Yes, definitely. They have got a better case, that's it.
Yes. Socio-economic conditions, my lord.
Social. Inter alia. There are other grounds also.
That is
Mr. Gupta, it's not only a question of the ratio of the judgment that oral, yes, oral prayers, it can be orally allowed, but application, if application is made 137. But this section does not contemplate an application. Therefore, an order passed under section 5, how does it attract section 137, article 137 at all? Article 137 only speaks about an application where limitation is not provided. Section 5, the section does not contemplate an application. We can treat this application as an affidavit for bringing it to our notice the cause.
But possibly this has been interpreted in the 1992 Calcutta. If your lordship kindly
Cite
permits,
that
yes. Kindly permits.
We'll refer it to a larger bench and grant stay in the meantime, grant stay of the execution case. Admit the appeal, we have to also have to admit that. Article 137 is very specific.
There is a division bench judgment of my lord Justice A.M. Bhattacharya and Justice.
Yes, Justice Ray's part has been
Kindly
quoted.
takes a look at, but it starts from my lord 179. But I only have my copy, my lord. If your lordship kindly takes a look at page 185, where Justice Ray's judgment is there.
What was the view of Justice Bhattacharya? We'll also have to see, because you have read Justice Ray's view because Justice Chakraborty quoted him.
Yes.
Oh. Justice Bhattacharya held otherwise. That was the dissenting view. There was
No, there was no dissent. There was no dissent.
Para 14?
There was no dissent, my lord.
Para 14, 15. You have got. Look at his copy of the judgment. just see what was done here. But Justice Bhattacharya clearly held that Section 5 is not, this is not applicable to Section 5. The finding is at page 14.
Paragraph 14.
Paragraph 14, sorry.
Yes.
There is no such period, thus no period of limitation for an application under Section 5 Limitation Act. And that is the right view. Justice Ajaynath Rai held internally on the basis of Kerala State Electricity Board case, general applicability of that provision.
137.
137 itself is general in its
Yes,
application. But then goes on to say state has not even sought to explain the delay of nearly 3
Firstly,
years.
this was a mandamus appeal from a writ petition.
Maybe.
Secondly,
Yes.
the appellant was state. So in that view,
State is not a favored litigant.
but in a Section 5 is always a favored-
Definitely not. Absolutely not. We have held otherwise in several judgments. We have dismissed applications under section. State cannot ever be a favored litigant. No. How can the state be a favored litigant? We can construe the red tapeism in a state department and take a view on that. But state cannot be nobody is a favored litigant. State is an unfavored litigant as per the constitutional scheme. Every relief is against the state in the constitution. Justice Rai says the state has not even sought to explain the delay of nearly 3 years. But in fairness, this is because neither side realized that Article 137 was already standing in the way. However, a barred application should ordinarily be dismissed, whether the point is specifically taken. As such, this application is liable to be dismissed, but for the prayers for admission of appeal made on behalf of state, which I beneficially construe as an informal oral prayer for condemnation. So they sought for admission of the appeal. That was construed by the judge by one of the judges as an oral prayer for condemnation of the deed. There was a sought for admission of the appeal. We are construing that as prayer for, and Justice M. Bhattacharya took the right view, Mr. Gupta. Absolutely right view. And
in paragraph 14, your lordship.
Paragraph 14, very clear. No, we are allowing the section. Learned counsel for the appellant argues that.
But, could I just show two pleadings from the Section 5? Or is it lordship?
What pleadings?
But, lordship can.
We will take it up tomorrow. Today is 4:30. We'll take it up tomorrow. You definitely have a right to argue, Mr. Babu. You cannot close your. Bring photocopies of this also, so that it's easier for us to mark and do whatever.
In the meantime, I'll see if I can
find out anything else. Yes. Justice Chakkudi's judgment also keep with you. Just cite tomorrow when you do. Due to paucity of time, the matter cannot be concluded today. So accordingly, let the matter stand adjourned till tomorrow.
Grateful, my lord. Regarding item number 64, there is great urgency in this matter. If this matter can be taken up tomorrow at any time, my lord, there are 100 students in the age range of 2 to 5 years who studies in this school.
কালকে কিছু আমাদের সকালে 10:30 কিছু কোন ফরওয়ার্ডটা বল We have already disposed of several applications today. This will retain its position in any event. It will go up a bit, maybe.
Great. Item 64.
কালকে 2 PM তো ম্যাটার আছে না কালকে না এটা রাখবেন না এটা না ভালো মনে করেছেন কালকে 2 PM